my lord, though it has been fixed for hearing, my lord, it will take hardly some time. So covered by Rafiq Masih, my lord. Maybe fixed on Friday, my lord, if possible. Much obliged.
We are not listing matters for hearing. We are listing it for orders or admission. We can list it for orders,
My lord.
but not on Friday. It can be on 1st of March.
Lord,
1st of March,
can it be preponed, my lord?
21st. 21st February.
Much obliged, my lord.
Yes.
May I please, Your Lordship? Lordship, with the consent of the opposite party, Lordship, I beg to mention item number 37 to 44. Lordship, kindly adjourn this matter for today.
Why?
Lordship, Mr. A. Suma is out of station.
2013 matter.
Lordship.
Then?
Only
You
for
wait.
today. Today only.
Let the matter be called up. You wait. You wait. Let the matter be called up. Let us see what these matters are.
Lordship.
Okay.
May I please? So I propose listing through WBC my lord, for admission. My lord. In this case, my lord, only notice was issued. My lord, they are not come, my lord. On next one, my lord, no affidavit has been filed.
21st February.
Highly obliged.
Similar prayer matter for listing
Admission.
orders.
Orders. 21st.
My Lordship, I beg to mention for listing in order matter of last
21st February. Yes.
May I please, lord? I praying for the withdrawal, lordship. Day after tomorrow. Lordship.
Withdrawal.
Tomorrow.
Tomorrow.
Another prayer, lordship, listing, lordship.
For
Orders.
21st February.
Lordship, kindly allow this matter for listing tomorrow. Lordship.
Why?
Lordship, this matter is filed on 4th January 2014, 2024. The petitioner was suspended by alleging certain allegation against him. Though
New
he was
matter or old
suspended,
matter?
He has
Is it
survived
new
to
matter
the
or old
fact
matter? Fresh matter.
Yes.
Recently filed.
4th January.
It has not been listed before the court.
No.
Why? Why not listed? Some defects maybe?
Sorry, matter.
You check up with the registry. You check up with the registry why the matter is not listed, which is normally listed within 48 hours. There must be some defects. You check up. Then you make a mention tomorrow.
That is a lordship. I beg to mention for listing of a requisition, lordship, on Friday or Thursday, lordship.
What matter?
Lordship, motion matter regarding pensionary benefits. The lordship directed to be listed within January, but it has not been listed.
21st February.
Lordship. Obliged.
Mr. Mozumdar was here, but he has called up. But in any case, also in this case, some instructions were called for in the last order of the Honorable Court, Your Lordship. But those instructions have not arrived, Your Lordship. So the department has asked us to pray for 4 weeks' time, Your Lordship.
4 weeks.
Our department has prayed for that much time, Your Lordship.
No, you tell us when this is only a question of their notification.
Lordship, they are saying they're having some difficulty in locating the notification 2006-7 because their contact is another department. Something of that nature has come from the department in written form, Your Lordship. Information sought for in the instant case needs to be collected from other
So
departments.
is the department aware that the matter is a parted matter? The department is probably not aware. You should apprise them. This is a parted matter. All right. So
Fixed date may be given, Your Lordship.
we'll have it on 20 February.
Lordship.
You find out if that notification is there or not.
Lordship.
List on 20. At the request of Mr. C.S. Hazarika, appearing for the government, requesting for further time to apprise the court as to whether any order has been passed by the permanent committee and whether any notification has been issued by the state for implementing the Child Marriage Protection Act 2006 in the state of Assam.
Interim order may kindly be continued in both the cases.
There is already an interim order. Last state we did not extend the interim order. So if it is there, it is there. Interim order passed earlier will continue till the next date fixed.
Obliged.
Obliged.
Yes.
In the last occasion, Lordship, my learned friend from the department was directed to take further instruction, Lordship. I was also instructed to furnish some documents, Lordship, basically the bank statement, Lordship. That was verbally stated.
You are what?
Lordship, I received my monthly salary till the date of my retirement, Lordship. So far, bank statement is concerned, Lordship. Regularly, I was paid the salary of junior inspector.
Who's for the respondent cooperation department? Yes.
Lordship, others have received the instruction, Your Lordship.
Yes.
Now, both the petitioner and the person whose name is reflected in the provincialization list are two different persons. And I have received the instruction allowing the service copy of the Abdul Hamid, whose name is reflected in serial number 436 of the provincialization list, Your Lordship. And as per my instruction, Your Lordship, which I have received is that the petitioner, there is no service book available during his cadre, during his appointment as a cadre secretary, Your Lordship.
No, by these documents, what do you want to show?
Lordship,
Who has
Yes,
given
sir.
this?
bank statement, Lordship.
For what purpose?
I was paid, Lordship, till the date of my retirement. Page number 17, Lordship.
Hmm.
This was the last payment, Lordship. It was the regular payment, Lordship. On 4/12/2009, I received my last salary, Lordship.
You were supposed to place some instructions.
Lordship.
What instructions have you got?
Instruction, Your Lordship, on the last occasion, I have given an instruction that proposal has been sent for provincialization of the petitioner. That apart, Your Lordship, today I have the service book of the Abdul Hamid, whose name is reflected in the provincialization list in serial number 436, Your Lordship.
You tell
Now-
us
Lordship.
whether, see, if a person is provincialized, then he'll receive his salary.
Lordship,
You tell us from your documents in respect of Abdul Hamid.
Lordship. The present petitioner.
Abdul Hamid.
Abdul Hamid,
According to the department, there is one Abdul Hamid,
Yes, Your Lordship.
but he is not the petitioner,
Lordship.
right?
Lordship.
So in respect of that Abdul Hamid,
Lordship.
for whom you have released the salary,
Lordship.
in which account has it been credited? What is the bank account?
Lordship. Lordship.
These details will be there available with you.
Right now, I don't have, Your Lordship. I only have the service book of Abdul Hamid, whose name is reflected in the
Why are you not trying to understand the query of the court?
Lordship. Lordship.
We are trying to find out whether the Abdul Hamid in the department is the Abdul Hamid of who claims to be the petitioner.
Lordship.
You are not assisting the court. We want these instructions from the department. You are paying salary to a person who has who according to you has worked,
Lordship.
but he's not the petitioner,
Yes.
some other person. You show us from your documents, he has produced some bank statements.
Lordship.
You show us that this amount of salary has gone to this bank's, this particular account or what account?
That Abdul Hamid got determined in the year 2003 lordship, and I was in the year 2010 lordship. Till 2010 lordship, I was paid lordship regularly. My pay was also protected lordship.
Have you understood the
Yes,
issue?
yes, your lordship, I understand.
Or we'll have to call your officer who's
No,
instructing you
No, your lordship,
with all the records.
no, your lordship. Regarding the salary, release of the salary, your lordship.
We are not asking you release of salary or release of benefits. We are asking you on what basis are you saying that these two Abdul Hamids are not one and the same?
different
What is your basis for making this statement? We want to see that you must be having some documents. Do you have the service book?
Yes, your lordship. I have.
Does it contain a photograph or something?
No, your lordship, it has the fingerprints, your lordship.
What is the address given?
Address given in the service book is your lordship. P.O. Tiamari District, Dhubri. And his father name is late Momin Sheikh. In the service book. Whereas your lordship, in case of.
You are different. You are
Different.
Ilfan Mandal.
Yes, yes.
Then,
Lordship.
so there are two different
Two different persons.
persons.
It is a fact that there are two different persons.
Uh.
It is a fact. But my service was also provincialized lordship. So far records are concerned lordship.
Where is that record?
Annexer 6 may kindly be page 12. Page 12.
Annexer
6.
6?
6.
There is no
Annexer C-
6.
Annexer C lordship page 12.
Annexer C.
Lordship.
Now, is this order issued by the department?
Lordship.
Page number 12, 13?
12, 13.
Lordship.
Hmm?
It ought to be a lordship.
Then lordship page number 17 annexer F.
This is issued by the department.
Yes, your lordship.
Then?
Now, the problem which we are facing right now is that his name is somehow not included in the provincialization list, your lordship. And for that, we need the approval from the higher authority to get.
Yeah,
his-
how have you released the salary?
That is a question, your lordship.
How have you released the salary? Who has released the salary? What have you stated in your affidavit?
Lordship.
So lordship kindly comes to paragraph 5 of my affidavit, your lordship. It says that as per notification dated so and so, the service of total 516 numbers of cadre secretaries were provincialized to the rank of junior inspector auditor of cooperative societies, allowing to the count of past service with effect from the initial date of joining in service as cadre secretary. It is pertinent to mention herein that only one name, that is Abdul Hamid, was placed in serial number 436 of the aforementioned notification, who joined in service on 16/1/1979 and retired from service on 31/12/2001. And accordingly, he is getting his pension. Now, in this case, the petitioner, he got retired in the year 2009, your lordship, and his date of appointment is of
1975.
75, your lordship. Then very next para, your lordship, we have stated that a petitioner joined in service on so and so and got retired from service on so and so. Now, both are two different persons, and somehow at that point of time, his name was not included in the provincialization list, your lordship.
Now, what have you done regarding this provincialization?
Now, recently, your lordship, on the last occasion, I have placed an instruction whereby the registrar has written a letter to the secretary to the government of Assam to include the name of the petitioner in the provincialization list with retrospective effect, your lordship. And that particular process is still awaiting.
Where is that? Where is that letter?
Lordship, I have placed it on the last occasion. So lordship kindly comes to the second page, the last paragraph. There's a letter from the Registrar of Cooperative Society to the Joint Secretary. The last two lines, your lordship, from the bottom. Now, without including the name of the petitioner in the provincialization list, the pension could not be, your lordship, released.
Yeah, who represents the secretary?
Secretary, I'll represent, your lordship.
So what steps have been taken by the secretary?
Lordship, it is under process, your lordship. As per my telephonic instructions, we have received yesterday, your lordship.
Who has received yesterday?
I have received telephonic instruction, your lordship, from the concerned officer. It's under process, your lordship. It will take some time, your lordship.
What time?
It's 4 weeks time, your
Why?
lordship.
Why?
No, to complete the entire process, your lordship.
Meanwhile, what benefits have you offered to the petitioner? We can give you 4 weeks if you undertake to complete the entire process.
Lordship, I'll assure you that.
But be aware, you are giving an undertaking to the court. Violation of that amounts to
Lordship,
contempt.
I'll communicate to my concerned officers, your
So
lordship.
we can give you 4 weeks, provided you say that this can be completed.
I'll communicate, your lordship, immediately. I'll communicate.
We have modes of communication. We don't require a council to communicate to the department. We are making it clear.
Right.
You are under instructions to pray for further time, aren't you?
Lordship, lordship. Otherwise, your lordship, the service book I have received, lordship. Regarding that, these two persons are two different persons.
Service book belongs to somebody else.
Yes, your
Does he have a service book?
No, that's what I'm making my submission on that point, your lordship. Regarding his tenure as a cadre secretary, there is no service book available in the department. Because these particular petitioners and the other persons were promoted from the cadre secretary to the junior inspector, your lordship. And there is no service book available regarding his tenure as a cadre secretary.
How is that possible? Where is the promotional order? How without a service book, without provincialization, a person is receiving salary and is now come up claiming for pension?
Lordship.
Where is the promotion order?
Promotion order, lordship, I only annexed the annexus 6, annexus C, lordship, which I feel it relevant, lordship.
But it says provincialized secretary.
Lordship, no
Order says so.
promotion, no promotion, lordship. Provincial.
When you have superannuated now.
Superannuated.
When?
2009, lordship, October 2009.
And where is that communication showing you that?
Lordship, page 17, lordship.
17.
Thereafter, lordship, so far the statement is concerned, lordship, one benefit was given to me, lordship. Perhaps that was, lordship, from retirement benefit.
So this is a very serious matter. You are allowing a person to work, giving him promotion, sending him
1994
letters,
Since 1994, Your Lordship.
then
If your lordship kindly come to the page number 10 of the bank statement, lordship, which I finished today, lordship. Page 10.
I am surprised that your commissioner and secretary has not issued an order for inquiry. Why?
Page 10 of bank statement, lordship. An amount of 1,60,042.
In fact, Your Lordship, our inquiry has been conducted. There is an additional affidavit filed by me.
Hmm.
In that, Your Lordship,
Where is it?
uh, additional affidavit filed by the department. Just
Paragraph 4.
paragraph 4.
Paragraph 4.
Paragraph 4, Your Lordship. Your Lordship, got it.
Page number?
Page number 2, Your Lordship, of my additional affidavit. Just filed on in the month of March 2021, Your Lordship.
Yes.
Now, the answering respondent states that as per order of the Honorable High Court, the respondent authorities has gone through the service records of the petitioner wherein it has been found that as per government notification so and so dated so and so, proposal has been sent to the Joint Secretary Government of
No,
Assam
that
for-
you have stated, but where is the inquiry?
Very good.
Very local district.
Page number 26. Lordship, adding page 26, lordship. Paragraph number 7 of the affidavit, lordship. Very good.
Alright. The answering deponent states that based on the letter dated so and so, an inquiry has been conducted and in the said inquiry, it has been found that the present petitioner joined as secretary under Assam Qadar Management Cooperative Societies Limited at Hastinapur in Borpeta district on 17/11/1975, and he was transferred to Tupamari GPSS Limited. But relevant documents regarding his transfer and postings are not available in the office file. However, the petitioner retired from service on so and so. It is pertinent to mention herein that the petitioner was removed from service by the order dated so and so dated 2/12/1986, and again the petitioner was temporarily appointed as a cadre secretary by number so and so dated 9/2/1993.
Where is that order? 9/2/93?
It will be at running page 43. Your Lordship, order. Sri Abdul Hamid is temporarily appointed as a cadre secretary at the scale pay of rupees so and so, as per the order of the government, white number so and so dated 4/2/1993. He will be treated on service from the date of joining. Now he has again been reappointed, Your Lordship, in the year 1993.
Where is his removal order? It must be in 93 or before 93.
Before 93, because he was suspended for a particular period, Your Lordship. He was removed from service.
What is the meaning of cadre secretary?
Cadre secretary, Your Lordship, they are appointed as a secretary of the cooperatives, VPSS, Your Lordship, initially. Then there, after that, they get promoted to junior inspector, Your Lordship, upon being provincialized. They comes under the cadre management, Your Lordship, of the cooperative society.
No, is it under the department or
Lordship, it is a part of the department.
part of the
Part of
department? What is the society? Assam Cadre Management Cooperative Society?
Lordship, they initially appoint only the secretaries in the cadre management, Your Lordship, just like the petitioner. Now, from there, Your Lordship, if the government approves, their names included in the provincialization list, that
And where was it terminated?
he was as per
Removed from service
he was
in
removed from
86.
service to 12/1986. He joined in 1975, removed from service in 1986.
Removed from service means removed as from service as what?
As a cadre secretary. But because his provincialization was after 1994, the notifications also says so, the 2006 notification, 5/1/2006, in which the name of the petitioner was not included. So before he was at that point of time.
No, we want to know one thing.
Gotcha.
How is it that a person who has been removed from service
Yes, Your Lord.
gets reappointed temporarily?
Yes, Your Lord.
Huh?
Yes. Instead of reinstating, he has been reappointed.
So it's not about reinstating. On what basis was he removed?
Lordship.
On what basis has he been reinstated or rejoined? On what manner? There's no documents about it.
Lordship,
No, nothing in the file.
there's nothing in the file as per my instruction, Your Lord. With respect to the cadre management, Your Lord.
Yes, Mr. Counsel.
I have.
When were you removed?
I have no instruction.
Very well, then we are dismissing your petition. What is this? What is this? This amounts to suppression now. Have you stated that you were removed from service?
No, Lordship.
Why?
Lordship, I was not aware of that fact, Lordship.
How have you responded to, have you filed a rejoinder?
No, no, no.
Then file a rejoinder. File a rejoinder and answer to the averments made in para 6, para 7.
Lordship.
We want your averments.
Lordship.
Counsel for the petitioner is permitted 3 weeks' time to file a rejoinder affidavit to bring on record a rejoinder affidavit in view of the statements made by the department in their counter affidavit at para 7 that the petitioner was removed from service in the year 1986 and thereafter temporarily appointed as cadre secretary in 1993. These statements were not pleaded in the writ petition. At the prayer of the petitioner, matter stands deferred for 2 weeks, 3 weeks. Mr. G. Bordoloi appears for the department. Meanwhile, you find out what steps have they taken. Yes. Where are the petitioners?
And a failure, Your Lordship. Even last occasion, this honorable court has directed whether the punitive charges of rupees 5,000 per wagon is liable or not. In that case, Your Honor, I have one instruction. That instruction, as per suppressing the other office memorandum, the guidelines of the 5,000 detention charge has been revised and no change have been done. So this is the instruction. So I have received one instruction, but I don't. So revised guidelines, it shows that it's been waived out. But I don't know what is the stand of.
What is the meaning of this?
Meaning is, Lordship, the earlier, the stand is there to 5,000 per wagon. That have been, my Lordship has asked me whether that this railway can make any formulation by their own way to levy the charges of the punitive charges at the railway station. And now I have got this new guideline. I have to correspond with my department. This is I have downloaded from the internet, Your Lordship. So let me,
So as on date, there is no levy,
no levy.
no levy.
No levy as per this instruction. Your
Ah.
Lordship. But one case has already been pending in the division bench. Your
That is
Lordship.
with regard to the virus. That is with regard to the virus of Rule 4.
Rule 4. Let
Then,
me, if Lordship permit me, let me, although the petitioner is absent, let me take a full instruction. On the next date, I will apply before the Honorable Court the stand of the NH Railway, whether it is.
what stand is there? It is already revised. As on date, as per this, there is no levy.
No levy.
So
I have
if,
to
if there is
confirm.
no levy, then there is no grievance of the petitioner.
No grievance over a petition. Otherwise, these petitioners become infractors.
Then,
Short date anyway.
petitioner counsel. So that will be- Have you informed the petitioners?
Yes, I have informed you. I have given one copy. Even he is supposed to argue the matter. His Honorable Court has directed the present status of this case to the petitioner actually.
You inform him, ask him to come at 2.
Right.
You get your instructions in the meantime.
Yep.
At 2 p.m.
May I please? My lord, the petitioner has put to challenge the letter dated 17/7/2021, page 52. This is with regard to the claim for his SCPS benefit, my lord. He was not given the benefit of SCPS. And this honorable court, my lord, in the order dated 12/5/2022, already recorded that the prima facie, this is incorrect. The calculation, the service blank they have shown is incorrect. I'm going to that manner. Petitioner was initially appointed. Petitioner was appointed as sub-inspector of schools on 5/11/1985. It was a direct recruitment process. And he was appointed as sub-inspector of schools. And thereafter, my lord, the petitioner was promoted to the post of block elementary education officer on 12/5/2010. That is beyond the period of 24 years. 10 years plus 12 years. That he has been promoted. And during that period of service, my lord, he was in the same post. And therefore, he is entitled to the benefit of SCPS. The impugn letter, what they have done, my lord, they have taken into consideration his previous service as assistant teacher and calculated his previous service towards the sub-inspector of schools. Sub-inspector of schools is a direct recruitment post, my lord. The finance department has given an affidavit, my lord. In the affidavit, they have taken a stand that he has been granted pay protection. Pay protection and service continuity, my lord, it's not the benefit under SCPS scheme, my lord. It's a benefit which is given to a candidate, my lord, after if he joins the new assignment, only to protect his salary, because otherwise his salary will start from the initial point. That is why he has been given the pay protection, so that he continues in the same scale of pay.
Yes.
That is there. As per SCPS scheme, my lord, he is entitled to the benefit of
What is the stand of the respondents?
respondent. The education department, they have not given the clear stand, but the finance department has given that they have given the benefit of pay protection.
No,
Pay-
there is an affidavit filed
Yes,
by
they have filed, my lord. We have given the
respondent-
reply also.
respondent to.
Yes, we have given the reply also.
Hmm. So they say that it was notified in 2011 and therefore you're not eligible.
That is wrong,
Why?
because this past service includes the service from the initial date of joining.
Where is that notification?
That is at page 33, my lord. Type copy I have given in the page 31. 31 is the type copy. Date of effect.
'31.
Yes,
Where is the date of effect?
the scheme would be operational with effect from 1/1/2011. In other words, financial upgradation as per the provisions of
We are reading from which page?
page 31, my lord.
31.
Date of effect, point number 3, in the bold one.
Point number 3. From 1/1/2011.
Yes.
Hmm.
The scheme would be operational with effect from 1/1/2011. In other words, financial upgradation as per provisions of SCP scheme would be granted with effect from 1/1/2011. Financial upgradation under the scheme. The first financial upgradation under SCP scheme shall be allowed after 10 years of regular service, and second financial upgradation shall be allowed after 24 years of regular service. In case of employees completing 24 years of regular service without any promotion, there shall be given 2 financial upgradations simultaneously. In case of employee who rendered 10 years or more of regular service, but less than 24 years of regular service without single promotion on the date of introduction of the scheme, that is 1/1/2011, first financial upgradation shall be granted immediately. The surplus years of 10 years shall be counted towards next 14 years span for allowing the second financial upgradation. Only 2 financial upgradation will be admissible into regular promotion if no regular promotion is given to the employees during the period prescribed. The financial upgradation would be admissible up to the highest grade of rupees such and such. Now the regular service definition is given, my lord. Regular service for the purpose of SCPS shall commence from the date of joining of a post in the direct entry grade on a regular basis, either on direct recruitment basis or on absorption re-employment basis. The service rendered on ad hoc basis, contract basis before regular appointment on pre-appointment training shall not be taken into reckoning. However, the past continuous regular service in another government department in a post carrying the same grade pay prior to regular appointment in a new department without a break shall also be counted towards qualifying regular service for the purpose of SCPS.
So the condition is that you should not be given, you ought not to have got any promotion.
Yes.
But according to the department, you have been given a promotion.
No, that is wrong.
Why?
Because, my lord, there was promotion in the year 2010.
Right.
After completing the tenure of 24 years. After completing the period of 24 years, therefore, I am entitled.
Joined in service in 85.
85 in the regular recruitment.
Hmm.
And even if, my lord, they count the previous service as my teacher, as a teacher, that will, as per
But
this definition, my lord,
24 years
yes, it comes
with,
on
with one promotion.
2009.
24 years with one promotion.
No promotion, the same benefit.
Huh? No.
I was appointed on 5/11/1985,
Right.
and I was promoted on 12/5/2010.
Hmm.
More than 24 years in the same post, my lord, a sub-inspector of schools, I continue.
No. I know that is your case, but
Hmm.
try to interpret this from the notification.
Yes,
Notification says 10 years, no promotion, you are entitled to first
benefit.
ACPS.
Yes,
24 years, no promotion, two ACPS.
yes,
24 years, one promotion.
first 10 years, then 14 years,
Huh. So
total 24 years.
first 10 years without a single promotion.
Yes. Second 14 years without the single promotion.
On the date
Yes,
of introduction of the scheme.
yes.
So on the date of introduction of the scheme, you had already been promoted.
On the date of, that is after completing 24 years. Therefore, my lord, the scheme says the counting of the entire service length, whether within that period I was given the promotion. That is the issue, my lord.
No, where in the scheme? Show us again.
Let me read, my lord, once again, my lord.
Yes.
I'm reading in page 31, my lord.
Yes.
14. In
No, not 14. You read from 11.
The scheme would be operational with effect from 1/1/2011. In other words, financial upgradation as per the provisions of SCP scheme would be granted with effect from 1/1/2011. The financial upgradation under the scheme. The first financial upgradation under SCP scheme shall be allowed after 10 years of regular service, and second financial upgradation shall be allowed after 24 years of regular service. In case of employees completing 24 years of regular service without any promotion, they shall be given two financial upgradations simultaneously. In case of employees who rendered 10 years or more years of regular service, but less than 24 years of regular service without single promotion on the date of introduction of the scheme, that is 1/1/2011, the first financial upgradation shall be granted immediately. The surplus years above 10 years shall be counted towards next 14 years span for allowing second financial upgradation. In my case, I have completed 24 years prior to that.
No, but you had got a promotion.
Promoted after 24 years. Therefore, my lord, while calculating the benefit, you have to, my lord, count the entire service length from the date of joining. And from the date of joining, my lord.
No, it says 24 years without any promotion.
Yes.
Huh.
I am without any promotion for 24 years.
When does your 24 year expire?
It expired, my lord, in the year 2009, my lord. It was calculated.
2009. But this 24 year
Yes.
without any promotion has to be on the date of the
No.
notification.
No.
How?
It is to be calculated with effect from 1/1/2011, my lord. Someone employs one.
No. You see. You read again from 12.
Yes. The first financial upgradation under SCP scheme shall be allowed after 10 years of regular service, and second financial upgradation shall be allowed after 24 years of regular service. 24 years of regular
No,
service.
then you come to 14.
Yes. In case of employees who rendered 10 years or more of regular service, but less than 24 years of regular service without single promotion on the date of introduction of the scheme, that is 1/1/2011, the first financial upgradation shall be granted immediately. In case of those employees, my lord, who have not completed, for them immediately.
So you are saying there are two criteria. One is 10 years plus, but less than 24.
Yes.
But on the date of notification.
Yes.
And so far as 24 is concerned,
24.
even if it is beyond
Yes.
prior to the notification.
Yes.
No, that is an interpretation that cannot be.
That is there, man.
No. Where? So what? Where? We don't read that. It is clear that it is with effect from 1/1/2011. The benefit will be from 1/1/2011.
Yes.
Effective.
Yes. Benefit will be effective, my lord. Only
So-
financial upgradation will be admissible if no regular promotion is given to the employees during the prescribed period, that is 24 years.
No, we agree with everything that
Yes.
from 24 years, after completion of 24 years, you are not given the promotion.
Yes.
Correct.
Yes.
But that promotion subsequently you got it, but before implementation of the notification, before the notification came into effect.
But the benefit, when it will be applicable, my lord, it will be counting from the date of joining, my lord.
Quite right, provided you are eligible for that benefit.
Yes, I am eligible because I
How?
have completed 24 years of service without a single promotion, my lord.
No, on
Without
the-
a single
no,
promotion.
no, 24 years on the date. Effective date will be that.
Yes, effective date, my lord. On that very day, my lord, it is benefit will be given with effect from 1/1/2011, not prior to that. Financial upgradation benefit will be given with effect from
No,
1/1/2011.
I don't think that is correct.
That
Yes.
that is the correct position, my lord.
The clause 14, my lord, is further clarified from the clause 16.
Yes.
May I read, my lord.
Yes.
If any post has been upgraded once and the employee has received the financial benefit due to upgradation within 10 years of service,
You're reading
page 35, my lord.
35.
Yes.
Okay.
Is-
Yes.
Page
Clause
35.
16, yes.
Clause 16. If
Mhm.
any post has been upgraded once and the employee has received the financial benefit due to upgradation within 10 years of service or on the date of introduction of the scheme, that is 1/1/2011, benefit of first financial upgradation under ACPS shall not be given to him. So it is on the date of introduction of scheme. If he has given some benefit, then he will not be entitled, my lord. Similarly, if such post has been upgraded twice before completion of 24 years as on date of introduction of scheme, that is 1/1/2011, or the post as upgraded once after the employee has taken the benefit of first financial upgradation under ACPS, but within 24 years of service, then benefit of second financial upgradation under ACPS shall not be given to him. In the instant case, my lord, he has granted the promotion. Before introduction of the scheme, he has granted the promotion. He has been granted the promotion. That is why he is not entitled, my lord.
That is what we are saying.
Exactly, my lord.
He says no, before 20, because he has already, his first promotion, according to him, came after 24 years.
Yes, my lord.
Therefore, he is entitled
No,
to the benefit.
but interpretation is different, my lord.
But the clause 16 and read with, I think, clause 14.
It is clarified that if on the introduction of the scheme, he has been given some benefit, either upgradation or promotion, then he will not be entitled for ACPS, my lord.
That is within the period of 24 years, this is written, my lord. In that event only,
But clause,
within 10 years and 24 years.
clause 13 says completing 24 years of regular service without promotion.
Yeah.
Yes.
They shall be given financial upgradation simultaneously.
But it has to be on introduction of the scheme, my lord. On introduction of the scheme, he has been given the promotion, my lord. In 2010, he has been promoted to the post of BEO. That is why this scheme is not applicable to him, my lord.
Yes.
That is not correct, my lord, because he has
In fact, clause 15 also,
15.
yes, 15
only
also same thing, my lord. Only two financial upgradation will be admissible if no regular promotion is given to the employee during the prescribed period of 24 years.
Yeah.
One, if an employee has got one regular promotion already, he shall be qualified for the second financial upgradation on completion of 24 years of regular service from the date of initial appointment. Number two, my lord, if an employee has got two regular promotion already, no financial upgradation will be allowed. In case of isolated post, there is no scope for promotion at all. The financial upgradation shall be allowed on completion 10 on 24 years. So, my lord, on introduction of the scheme, he has been granted the promotion.
no, my lord. This is not correct. No financial benefit has been given, no financial upgradation during that 24 years, my lord.
But come to clause number 2.
Yes, my lord. The benefit under the scheme would be given twice in the entire service period. First one after completion of 10 years and second one after completion of 24 years of service if they do not get one regular promotion within first years of regular service and 2 regular promotion within 24 years of regular service.
That is the thing, my lord.
But this has to be on the introduction of the scheme, my lord.
Introduction to the scheme, my lord, gives that benefit. Suppose I accrue the right, my lord, on the completion of 24 years, but the payment will be made, my lord, with effect from 1/1/2011, not prior to that. That is the effect. That is the effect. 1/1/2011 financial benefit. Salary will be increased with effect from 1/1/2011, even if I accrue the benefit on completion of the 24 years.
I don't think that is an interpretation. Maybe this is the interpretation in your case may not have been conceived of, but the whole purpose of this scheme is to give you some benefit in
Yes.
case you don't get a promotion.
Yes.
It is true that on 24 years you did not get a promotion, but you got it subsequently,
Subsequently,
yet prior to the scheme being brought into record. So may not be exactly in 24 years, you got it subsequently. So some benefit has been given to you.
that is
Is he entitled to further benefit?
No, my lord.
out of 2 financial upgradation, my lord, I have not been given even the single, my lord. Even if for the sake of argument, I assume, my lord, I have got 1 promotion, then also I am entitled to 1 upgradation, my lord. The scheme clearly prescribes, my lord, within 24 years, if there is no financial promotion, my lord, then only. As admitted fact, my lord, within 24 years, there was no promotion, no financial upgradation in my case.
So if you get 1 promotion, you get 1 financial upgradation or
Yes.
2.
Yes, my lord.
1 or 2.
1.
One promotion, then 1 financial upgradation, my lord. If 2 promotion, no financial upgradation.
So he's got 1 promotion,
He has got 1 promotion.
but he's entitled to another upgradation then.
Yes, sir.
My lord, but on the introduction of the scheme, he has been given the promotion, my lord, before introduction of the scheme.
He's been given 1 promotion.
Yes, my
Even, my lord, then.
He's given 1 promotion.
Yes, sir.
So
Even then I'm entitled.
the upgradation is to be allowed twice. First
Yes.
after 10 years, then after 24 years.
24 years.
Is it 24 years or after 14 years?
10 years first, then 24 years. 14 years. Total 24 years. If there is,
Where do you say that?
yes, lordship, it's I've
Clause
quoted.
12,
Clause 14, my lord.
Clause?
14.
Hmm. No, I think it is clause 12.
12 is
10 years of regular service, second, after 24 years
years
of regular service.
Yes.
in 14, it has been clarified that if in 10 years it has been given, then next 14 years, he is entitled, my lord.
So how many years of service have you got?
I have completed 24 years without any promotion, my lord. I've retired on 13, my lord. On 31/8/2013, I have retired.
So he'd be entitled to one upgradation.
As per this scheme, my lord, apparently, my lord, he has been granted 1 promotion, so he is entitled.
For one upgradation.
Yes, my lord, not 2.
My submission, my lord, within 24 hours, there was no promotion. Therefore, I am entitled to 2 upgradation. That is my submission.
All right. Both the matters are same.
Yes.
Anything more? Yes,
If I may, Lordship, if I-
yes.
here I have, we have filed an affidavit from Finance Department, Lordship. Uh, it's running page number 51, Lordship, it starts.
In which case?
Lordship, 5150 of 2020, Lordship.
5150, yes. Yes, tell us.
Para 10, Lordship, page
Hmm.
55 of our affidavit, Lordship.
Para?
Para 10, Lordship.
Yes.
Here we have stated, Lordship, fifth, like onwards, that the deponent, in addition to the so-and-so, the petitioner was appointed as inspector of schools on 5/11/1985, Lordship. However, as per, there was a contempt filed by the petitioner also. As per the contempt case number, the petitioner was initially appointed as headmaster of Bagbahar ME School in the district of Kasar, wide order dated 30/11/1971, Lordship. He was getting a graduate scale of pay with effect from 1/7/19. Thereafter, he was appointed as sub-inspector of schools under deputy inspector of schools, Silchar, wide order dated so and so, Lordship. Now, Lordship, the post of deputy inspector is a higher post than the headmaster, Lordship. Lordship, here, this is just our stand, Lordship. He was granted continuity service and pay protection. Further, he was promoted to the post of BEO wide order dated 12/5/2010, Lordship. So as per our record, Lordship, he was initially appointed as a headmaster. From there, he was appointed as sub-inspector, my lords. And from sub-inspector, he was appointed as BEO. So, Lordship.
These are all higher posts.
Yes, Lordship. So as per our record, Lordship, he has.
How is it that the education department doesn't have these records?
Lordship, they have not filed the affidavit. Lordship, I'm just trying to point out to you.
No,
Lordship.
their affidavit is there in the other matter.
Yes, Lordship. Lordship, now further, page 56, Lordship.
Yes.
Page 56, Lordship, second bar. It appears that the post of sub-inspector of schools is a higher post than the post of headmaster of ME School, Lordship.
Post of?
Post of headmaster, Lordship, where he was initially appointed. As such, protection, fixation of pay was allowed to the petitioner in the post of sub-inspector of schools as per FR 22C prevailing at that point of time. As such, the petitioner got the first promotional benefit, Lordship, in the post of sub-inspector of schools on the date of joining.
Hmm.
So from headmaster to Lordship, a sub-inspector of schools. Further, he was promoted to the post of BEO wide notification.
Which is the second benefit.
Lordship. This is from our record, Lordship. So, according to us, before the issuance of this notification, Lordship, there were two upgradations which the petitioner had already received. Although, Lordship, this decision has to be taken by the education department as he was an employee of the. As per our record, he is not entitled to any upgradation because this entire scheme was introduced, Lordship. Lordship, now if I may take to page 58, which is the notification itself. Here it's written the scheme would be known as Assured Career Progression Scheme for State Government and shall involve two financial upgradations, Lordship. There is no promotion, financial upgradations, Lordship.
Provided he was never promoted.
Yes, Lordship. Financial upgradation, Lordship. Under the ACP scheme for employees of the government of Assam, point 2, Lordship. Benefit under the scheme would be given twice in the entire service period. First one after completion of 10 years and second one after completion of 24 years of service.
He submits, his reply is that he was appointed as an SI through direct recruit, not on promotion.
Lordship, but there was as per our record, he was appointed as a headmaster also in the, if my learned friend is disputing that, Lordship, then
he has disputed by filing a reply affidavit.
Yes, Lordship, then that clarity can be given by the parent department. However, Lordship, this is from our record, the benefit under the scheme would be given twice in the entire service period, first after completion of 10 years and second one after completion of 24 years. If they do not get any one regular promotion within 10 years.
There is no dispute that he has been promoted to BEO.
Yes, Lordship.
There is no dispute. He also does not quarrel.
Yes, Lordship.
Dispute is with regard to your averments that he was appointed. You say he was appointed as sub-inspector.
Yes.
So this appointment of sub-inspector is not a promotion.
Yes, Lordship. Yes, that is there, Lordship. But as per our record, he was also working as the headmaster. He was Lordship in our.
He was initially appointed as headmaster.
Yes, Lordship.
Again appointed.
Then he was appointed as sub-inspector, Lordship. And now that clarity even we do not have because the record will be, if some clarification be given regarding that by the.
Is there is a sub-inspector to be appointed through promotion?
It's a direct recruitment.
Direct recruit.
Yes.
Yes.
Let me clarify, my lord. Look, number one, my lord, headmaster is a separate job, my lord. It was his earlier job. Number two, my lord, he was appointed to direct recruitment in the year 1995. That's 1985, my lord, and appointed on, my lord, 5/11/1985. And he completed his 24 years of service prior to his first promotion. That is the one thing, my lord. And what my learned friend has submitted, my lord, service continuity. Pay protection and service continuity includes it's a continuous service. And headmaster of the upper primary school, the skill and pay of the headmaster of the upper primary school is equivalent to the sub-inspector of schools, my lord. That's why, my lord, government has granted the pay protection so that he doesn't fall in the bottom in the pay scale, so that he continues it from his earlier pay scale. That is why, my lord, it's a continuous service. And so far as the, my lord, definition of regular service, may take your lordship to page number 37 of the writ petition. The scheme has itself given the definition of regular service. What is regular service? Regular service, for the purpose of the SCPS, shall commence from the date of joining of a post in direct entry grade on a regular basis, either on direct recruitment basis or on absorption or oblique re-employment basis. Service rendered on ad hoc basis, contract basis before regular appointment on pre-appointment training shall not be taken into reckoning. However, past continuous regular service in another government department in a post carrying same grade pay prior to regular appointment in a new department without a break shall also be counted towards qualifying regular service for the purpose of SCPS only and not for regular promotions. However, benefits under SCPS in such cases shall not be considered till the satisfactory completion of the probation period in new post. Regular service shall include all periods spent on deputation, foreign service, study leave, and all other kinds of leave duly sanctioned by the competent authority. Meaning thereby, my lord, the continuous pay protection and continuity, my lord, is a continuous service. If my learned friend's stand is taken, my lord, then my service will stand, my lord, with effect from 1977 till 2009. There is no promotion, my lord. It will be 34 years, not the 24 years. It will be 34 years without any promotion. If my learned friend's contention is taken and the previous service is counted, my lord, as per the scheme itself, it will be 34 years. In the para 7 of my reply, I have given the statement, my lord. Graduate scale. What of the chemical is the graduate scale of pay And the SI is British Columbia.
All right.
My humble submission, my lord, I am entitled for two financial arbitration.
Here, the administrative department can take a call regarding if they can analyze the case, keeping in mind the OM and keeping our stand. And
If everything is left to the administrative department, then what is the point on coming to courts?
yes.
They have filed their affidavit in the other case, the same thing, my lord.
Hmm?
They have filed the affidavit in other case, my lord, in the education department.
Okay, heard learned counsel for the parties, this two writ petitions are taken up for disposal as the issues involved in these two writ petitions are similar. In WPC 5150, the writ petitioner was appointed as sub-inspector of schools on 5/11/1985 in the Department of Elementary Education. And he joined in the state post on 29/11/1985. Thereafter, he was promoted to the post of BEEO after completion of more than 24 years of service, continuous service as SI of schools. Stop. Petitioner superannuated on 31/8/2013. His promotion was regularized on which date?
4/3/2016, my lord.
No, that is the date with effect from.
With effect from date of my initial promotion to 12/5/2010.
Where is that letter 4/3/22?
4/3, page 22.
He was regularized with effect from his date of joining on promotion. He was regularized by notification dated 4/3/2016 with effect from the date of joining on promotion. In WPC number 6984, the petitioner
In this case, we have challenged the impugned letter, my lord.
Was appointed as sub-inspector of school on 5/11/1985, in which post he joined on 29/11/1985. Stop. He was also temporarily promoted to the post of BEEO after completion of more than 24 years of continuous service as SI or schools under the establishment of DI of the schools. Stop. He was regularized by notification dated 4/3/2016 with effect from the date of initial joining and is superannuated on 31/8/2013. Both on the same dates.
Both the same person, my lord, same person.
Same person.
Same person.
Oh.
And in this second case, we have challenged the impugned letter, my lord, page 52, because during the pendency of the earlier case, they have issued the impugned letter rejecting the claim. That's all. The second case.
Which is the second case?
Second case, my lord,
69.
6984.
Oh. You're right. WP, both the writ petitions are filed by the same person. This is the so-and-so joined on so-and-so date. The WPC 5150 was filed by the petitioner claiming the benefit of ACPS.
ACPS.
Which was introduced by the government of Assam by notification dated 25/5/2011. Stop. According to the petitioner, having completed 24 years of regular service, as he was not given any promotion or as he was not given any promotion within prior to completion of 24 years of service, he is entitled to two benefits under the ACPS scheme for financial upgradation with effect from the date of its notification, namely 25 May 2011. Stop. Next, you write WPC. Being aggrieved, he has approached this court praying for direction to the respondents to grant him benefits of financial upgradation under the so-and-so scheme. In WPC 6984, petitioner has assailed which notification?
Impugn order, my lord, dated 17/7/2021,
Page
page 52.
52. Has assailed the order dated 17/7/2021,
Issued by the director, eliminated.
issued by the director, rejecting his claim for financial benefits under ACPS. Stop. Learned counsel for the petitioner submits that in terms of the scheme, petitioner having completed 24 years of service on the date of completed more than 24 years of service on the date of the notification by which on the date of the notification dated 25/5/2011 by which the ACPS scheme was introduced, as per the scheme itself, he is entitled to two financial upgradations. Stop. It is submitted that under the scheme, an employee is entitled to first upgradation after completion of 10 years of regular service and second financial upgradation after 24 years of regular service. Stop. These financial upgradations are to be allowed under the scheme if the petitioner is not granted any promotion within the time frame specified or any financial upgradation. Stop. The learned counsel for the petitioner submits that after, upon completion, till the time the petitioner completed 24 years of service, he was not promoted or given any financial benefits. Stop. He, however, was promoted to the post of BEO on
my lord, 12/5/2010.
On 12/5/2010. Stop. Therefore, in terms of the provisions of the scheme, he is entitled to two upgradations. Stop. Para. No, you're right. Denial of these benefits as prayed for is contrary to the scheme itself, and therefore he has approached this court seeking appropriate redirection or order. Stop. In the subsequent writ petition, namely WPC so-and-so, his claim has been rejected by the order dated 17/7/2021, which is put to challenge. Stop. Para. The Education Department has filed their counter affidavit disputing the claims of the petitioner, holding that since the petitioner was granted a promotion in the year 2010
Yes, sir.
to the post of BEO, he does not fulfill the criteria under the ACPS scheme, which was brought in effect from 25th May 2011, and therefore he is not entitled to the benefits as prayed for. Stop. The respondent counsels, relying on the affidavit filed, submits that since this benefit is meant for employees who has never received any promotion or any financial benefits on the date of the implementation of the scheme, the petitioner is not entitled as he had been given the benefit of promotion to the post of BEO on 12/5/2010, and therefore there is no infirmity in the impugned order dated 17 July 2021 issued by the Department of Elementary Education rejecting the claims of the petitioner. Stop. Para. The Finance Department has also filed an affidavit in which matter 5150?
Yes, Lordship, 515020.
In 5150, rejecting the claims of the petitioner. Stop. It is stated in the affidavit that the
Page,
petitioner, yes, petitioner,
page 55, Lordship, para 10, we have stated that the petitioner was initially appointed as a headmaster.
he was initially appointed as a headmaster of Bagbahar ME School in the district of Kachar by the order dated 30/11/1971. And he was getting a graduate scale of pay with effect from 1/7/1977. Stop. Thereafter, he was appointed as sub-inspector of schools under the deputy inspector of schools, Silchar, by the order dated 5/11/1985. Stop. He was granted continuity of service and pay protection. Stop. By order dated 12/5/2010, he was promoted to the post of BEO. Under such circumstances, since the petitioner has been given the promotional benefit in the post of sub-inspector of schools by allowing appropriate pay protection as per FR 22C and subsequent promotion to the post of BEO by notification dated 12/5/2010, the benefits under the ACPS scheme is not available to the petitioner. Stop. It is submitted that this benefit under the ACPS scheme is available only to those employees who completed 24 years of regular service without any promotion. Stop. The scheme is available to employees who are given one upgradation if after completion of 10 years, no benefit of promotion is granted. And the second upgradation, which is to be allowed after completion of 24 years of regular service, if the petitioner has not been given the benefit of promotion. Stop. It is only under these two circumstances that the benefits under ACPS is granted. Stop. It is submitted that since the petitioner had been given the benefit of pay protection in a higher scale of pay as well as subsequent promotion to the post of BEO, the claims of the petitioner for further financial upgradation under the ACPS scheme is not acceptable, and therefore his claims are bereft of any merit. Stop. Para. Learned counsels for the parties have been heard. Pleadings on record have been carefully perused. by notification number so and so dated 25th of May 2011, the ACPS scheme was introduced by the government of Department of Finance, Government of Assam. Stop. In terms of the scheme, the scheme provides two financial upgradations for under the ACPS scheme for employees under the government of Assam. These two financial upgradations are to be provided under the scheme as under : First benefit after completion of 10 years of regular service, and second benefit after completion of 24 years of regular service if they do not get regular promotion within the first 10 years of regular service, or two regular promotions within 24 years of regular service. Stop. It is categorically stated in the scheme that it is only to provide financial upgradation, and it is not a regular promotion, nor would require creation of new posts for the purpose. Stop. Under the scheme, a screening committee was to be constituted in each department in the pattern of departmental promotion committee as per the service rules and orders to consider the case for grant of financial upgradation under the ACPS scheme. In case there are no service rules or orders available, standard screening committee for various appointing authorities shall be constituted. The screening committee shall consist of a chairman and two members. So, to make the ACPS scheme operational, the cadre controlling authorities shall constitute the first screening committee within a month from the date of issue of this notification to consider cases maturing up to 30th June 2011 for grant of benefits under ACPS scheme. The date of effect of the scheme is provided under the scheme is 1/1/2011. Stop. Clause 4 in the scheme lays down the procedure by which the financial upgradations are to be conferred under the scheme. A careful perusal of the various clauses and the sub-clauses under clause 4 reveals that the benefits of financial upgradation, the benefit of the first financial upgradation under the scheme will be allowed after 10 years of regular service if the petitioner has if the person concerned has not been given any regular promotion. So second, financial upgradation will be allowed after 24 years of regular service if the person concerned has also been not considered for promotion or any other financial benefits. Stop. In the event the employees who completes 24 years of regular service without any promotion, they shall be given 2 financial upgradations simultaneously. In case of employees who have rendered 10 years or more of regular service, but less than 24 years of regular service without single promotion, on the date of introduction of the scheme, which is 1/1/2011, the first financial upgradation should be granted immediately. The surplus years and above 10 years shall be counted towards 14 years for allowing the second financial upgradation. Stop. Clause 15, X5, 15 of the scheme lays down as under. Extract. Page number 65. Clause 5 of the scheme defines regular service, which shall commence from the date of joining a post in the direct entry grade on a regular basis, either on direct recruitment basis or on absorption or re-employment basis. Para. Having minutely examined the scheme and the clauses laid thereunder, what is evident is that the scheme is for financial upgradation, conferring 2 financial upgradation for employees having completed regular service of 24 years. First upgradation is to be conferred upon completion of 10 years regular service. Second, on completion of 24 years regular service. So, the only exception, the other requirement for being considered for financial upgradation is that the employee concerned should not be granted, should not have been conferred any promotion or financial upgradation during this period of time. So, in the fact of the present case, while it is contended by the Learned Counsel that he has completed 24 years of service and no promotion, financial upgradation has been granted. But from the averment made in the counter affidavit, and which position is also not disputed by the counsel, you see that he had been, you see that why it may be correct that the petitioner was not conferred any promotion or financial benefit from the date of his initial entry into the Kedar as SI. Which date?
SI Malot is appointed on 5/11/1985.
With effect from 5/11/1985, comma, he was not conferred with any uh, promotion or financial benefits for 24 years if calculated from the date of his initial appointment. Stop. However, he was granted promotion on
On Malot 12/5/2010.
on 12/5/2010 to the post of BEO, and in which post the petitioner rendered his service till his superannuation. Stop. As such, on the date of as such, on the effective date, as referred to under the ACPS, which is 25th May 2011, although strictly speaking, the petitioner was not granted any promotion prior to completion of his 24 years, but he was considered and promoted for the post of BEO on so and so date, which is prior to implementation of the ACPS scheme. Stop. Therefore, to say that the petitioner has not been granted any benefit or any promotion, and therefore is entitled to two increments, two financial upgradations as per the ACPS scheme, cannot be accepted. Stop. Such contention by the petitioner is therefore rejected. However, the fact remains that in terms of the scheme, an employee is entitled to two financial upgradation. The first upon completion of 10 years, and the second upon completion of 24 years of regular service, if there is no benefit or financial upgradation granted to the petitioners, to the employee. Stop. The scheme proposes two financial upgradations in the absence of promotion. Stop. And the period of service required is 24 years of regular service. Stop. There is no dispute that the petitioner had already completed 24 years of service on the date when the ACPS scheme has been implemented with effect from so and so date. As such, although the petitioner had been given the benefit of promotion to the post of BEO on so and so date, and thereby he may not have been entitled to the first upgradation, financial upgradation, as contemplated under the ACPS scheme, However, his claim for the second financial upgradation ought to have been considered, since on the effective date when the scheme, ACPS scheme, was brought into service, which is 25/5/2011, petitioner had already rendered 24 years of regular service with one promotion. Stop. What about the screening committee?
As regards the screening committee is concerned, my lord, whether it is operational or not, my lord, I have to open the instruction.
Every department has a committee, Malot. Every year they sit for granting the benefits under this scheme. SCPS and MSCPS, every department has a committee. Periodically, they sit and examine them.
Under such circumstances, this court considers, has arrived at a conclusion that in terms of the scheme, ACPS scheme, brought into effect on 25 May 2011, and having satisfied the criteria prescribed under the scheme, under the scheme of completion of 24 years of regular service, and also keeping in view the benefits conferred under the scheme, which is 2 financial upgradations, as the petitioner had already been promoted prior to the effective date under the scheme, he would still be entitled to 1 financial benefit upgradation under the scheme. Therefore, the respondent authorities are required to pass appropriate orders allowing the financial upgradation to the petitioner and convert the effective financial benefits which will add up to his pensionary and other retirement benefits. The writ petition, therefore, is allowed to the extent indicated above. Writ petitions. The impugned order dated. The impugned. Is this an
17
order or a communication?
Communicate 17/7/2021.
Page number
52, my lord.
52.
WPC 6984.
The impugned order rejecting the claim of the petitioner communicated impugned order of the Director of Elementary Education dated 17/7/2021 rejecting the claim of the petitioner for financial benefits under ACPS is therefore set aside. The department will now proceed to allow the financial 1 financial benefit or i.e. the second financial benefit, second financial upgradation / benefit to the petitioner and quantify the amount which will reflect in his retirement and pensionary benefits. The entire exercise will be completed within a period of 60 days from the date of receipt of a certified copy of this order. Writ petition disposed of in terms of the above, no orders as to cost.
Obliged.
Interim orders, if any, stands marked, pending I is dismissed.
May it please your lordship. Last occasion, this honorable court has directed us to take instruction.
What
have
instruction?
My lord may dispose of the matter because of the pendency of the writ petition 997/2020. We kept pending of the petitioner pension. Now this honorable court has dismissed that petition. Now we are processing his pension. As said.
How much time do you require?
Lordship, we have already process been started. He will get.
Yes, Mr. Bhuya.
My lord, that can be disposed of, my lord, the very writ petition, my lord, by virtue of which, my lord, my case was not considered. That has been dismissed, my lord, long back, my lord. And I retired, my lord, 31/10/20, my lord. 4 years gone by, my lord. My pension has not been provided to me, my lord.
Okay, heard learned counsel for the parties. Anything to submit?
My lord, my instruction is that we have not received the proposal till date.
This is a communication on 3rd. So you'll get it sometime. Heard learned counsel for the parties. This writ petition is referred by the petitioner praying for release of his pension pursuant to rendering his regular service and superannuating from the department. Which department is it?
Industries and Commerce, my lord.
Industries and Commerce Department on 31/10/2020. Stop. Petitioner rendered 25 years of service and is therefore entitled to for grant of pension. Stop. What is your stand in the affidavit?
Affidavit, Lordship may kindly have a look. Paragraph 5, my lord.
The affidavit filed by the department reflects that the final pension proposal of the petitioner is sub judice before a coordinate bench in WPC 997 of 2020. And
2010.
which was against which a writ appeal being writ appeal number 253 of 2013 is also pending, and therefore the steps could not be undertaken to process the claims of the petitioner for pension.
Sure.
On
Pension and other benefits.
pension and other retirement benefits.
Gratuity,
Para.
including everything.
On earlier dates, the matters were adjourned to enabling the councils, both councils, to apprise the court as to the status of the writ appeal. Stop. Today, when the matter is called up, Learned Department Council submits that both councils submit that the writ petition the writ appeal was disposed of.
Lordship.
Writ appeal recommended, my lord, for honorable single judge.
Remanded.
Remanded.
The writ appeal so-and-so was disposed of, remanding the writ petition 997/2010 back to the learned single judge for redeciding the issue. Stop. The coordinate bench by judgment and order dated
29/2023.
2009/2023
Sure.
dismissed the writ petition. Who filed the writ petition?
Some
Some other persons, my lord, challenging all the
appointment.
appointments, including my appointment,
What appointment?
my initial appointment.
Initial appointment.
My
Initial appointment, my lord. When my lord,
So this is writ petition 2010.
10
Yeah.
matter, my
Writ
And-
petition so-and-so challenging the initial appointment of the petitioner
and other persons.
and other similarly situated persons came to be dismissed. Stop. Learned Department Council submits on instructions that since the writ petition has been dismissed and the order has been communicated to the department, the steps have been taken for facilitating the release of the petitioner's pension and other retirement benefits. Para, Mr. J.I. Borboya, Learned Counsel for the petitioner, submits, does not dispute this position. He submits that the writ petition can be closed with a direction to the respondents to expedite the process of release of pension. Stop.
Timely, maybe.
Para,
Expedite.
having heard counsels for the parties and upon due consideration of the submissions made, this court is of the view that since the Department Council has expressed no impediment in the completion of the orders, in completion of the steps taken for release of pension and other retirement benefits, this writ petition can be closed, taking into consideration the submissions made. Accordingly, writ petition is disposed of with a direction to the respondent number,
Lordship, all the respondent, because we have
to the respondent number 1, 2, and 3, 1, 2, 3, 4, to expedite the process of finalizing
5 million.
the pension papers
Yes.
and forward the same to the Office of the Accountant General, who in turn will process and endeavor to release the pension as expeditiously as possible,
Lordship.
as per provision of law.
My lord. Lordship may give my instruction as a part of the record, my lord.
The instructions received by the Department Council is placed before the court, which is kept on record. Stop.
Right.
This
Thank you.
entire exercise we completed within a period of 60,
One-
60 days
60 days, my lord.
from the date of receipt of a certified copy of this order.
My lord.
Writ petition accordingly disposed of, interim orders, if any, stands vacated. Pending I is dismissed.
Lords, deeply obliged, my lord.
Yes. Anything more?
No, my lord, only area, my lord, including one what can be, and other area,
Other retirement benefit also already recorded.
areas, আছে না কিছু there.
Have you prayed for arrears?
Yes, no, my lord, I have prayed, my lord,
Area what area?
not area, my lord, I have prayed, my lord, lordship kindly have a look at page 18, my lord. Gratuity including regular pension as well as other benefit, including
Yes,
area,
Other benefit?
including area pension.
No.
A
Area
pension.
pension could be the entire pension.
Yes,
From the date of
the
retirement.
retirement.
Yes.
Deeply obliged, my lord.
Your lordship, in this series of cases, my item is 24. In this case, your lordship, I have given an example. The similar candidate has been awarded 10 marks, your lordship, and I have been awarded 2 marks. To that, they have submitted a reply that that candidate has been wrongly awarded 10 marks, and subsequently, he was also not selected on other grounds, your lordship. Again, I have been able to collect.
What is under challenge?
The
What have you
challenge is
challenged?
Not allotment of the entitled full marks as rendered service under SPO, your lordship. As well as in
No,
some other
full mark where?
cases.
Full mark
homework.
where? For what examination?
It was for the post of constable, your
This was
lordship.
an advertisement for recruitment to the post of 145 post of constables in AISF. And this was not an open category. The applications were invited from people who had served as SPO,
Experience.
Special Police Officer.
And then home guard.
And some marks were also allotted. As per the advertisement, 1 year of SPO experience would give 2 marks, and 1 year of home guard experience would give 1 mark. So here that was not given. That is the issue.
I'll take up one by one, my lord. First of all, the 13. We have filed affidavit here.
Yes.
Further, I have again been able to collect
No.
some
item number
documents.
13.
I'll file additional affidavit.
First,
your-
first, first
Oh,
matter.
Why are these matters for admission? They should be heard.
Yes, hearing should be fixed, my lord.
Yes. Yeah, it can be
Because
fixed for
their allegation only because their experience certificate marks is not awarded against their experience
Is
certificate.
there any interim order?
No, my
No,
lord.
interim order is not there. Lordship, may I propose one thing?
Yes.
That Lordship, without going into, per case basis, because a lot of petitioners are there. May I suggest one thing, that if I can show few discrepancies demonstrating to the court that there has been discrepancy in the selection process. So if that is so, if ultimately it is sent back to the department, and then also it is, at least for my 3 cases, I can say that. And
No, first of all, let him, my lord, establish his own case.
yes, of
He is
course, I will.
appeared for 13. Yes,
yes.
let him. do.
If I can demonstrate.
No, my lord,
that there are-
this is not, they are not making any party against the person alleged. Even the, my lord, we have filed an affidavit. And that allegation has been, my lord, beat up. He was not selected. He was not made party event. Then let them one by one, my lord, establish their cases. Whether their certificate has been submitted or not.
Who is
Reporting.
appearing in WPC 3734?
Yes,
Lordship, I am there.
This is
He-
your matter.
Yes.
yes. 3734, let him establish his case, my lord.
No, what is your case first?
Yes.
Tell us, what is your case?
Lordship, for that, Lordship may come to the advertisement,
Hmm.
which is in page number, which starts from page number 35.
30?
35, annexure D. Because the whole story starts from here.
Yes.
And prior to this, some backdrop is there, not much relevant.
No,
actually.
now let us understand one thing.
Yeah.
This advertisement you are challenged. Your ground is that you, in terms of this advertisement, you had applied.
I had applied,
You are not selected.
not selected.
Now somebody else was selected.
Yes.
Have you added them as parties?
No.
No, we have not added them because when we had filed this case, the whole selection process was not complete. And of course, the learned departmental counsel, senior government advocate is there. He'll be able to apprise better because our instruction is that till now, although there is no interim, some posts are lying vacant.
have been kept vacant.
So they are matlab challenging the
Now-
select list. Why he is saying like that? The select list and to set aside and the make a
Fresh select list.
re-select list, fresh select list. Why they have come that they don't know about the select list? They know it about the select list. We have filed affidavit in this case. Only simple thing is because matlab they were submitted some certificate. Home guard certificate.
This is a 2022
This,
17
these are
select
these are 17 advertisements.
advertisement.
But it took a long time for the whole process to be over.
Then when was it published?
2021.
In 20,
Select list for an advertisement of 2017.
yes.
No.
No, final selection was 21 and 22.
22, my lord.
22, my lord. It took a long time.
22.
Advertisement is 2017.
Advertisement is 17.
It took 5 years for selection.
Yeah, my lord, it takes some time, my lord.
Why?
But district-wise selection was made, my lord. Physical test and PST and PEs. So thereafter, I come to the state selection, like step by step.
Acha, Lordship, let me quickly
Yes,
demonstrate
yes,
in
yes.
few minutes. 35, Lordship, the advertisement is starting. And Lordship, in the first paragraph, Lordship will see for selection of candidate for filling up 145 post of constables from SPOs. So this is an advertisement calling for application only from the SPOs. Now thereafter, Lordship will see in page 50. In page 50, starting from page 49, breakup of the marks awarded for extracurricular activities. Then coming to page 50, experience as SPO will earn 2 marks for each qualifying 1 year.
That is
Now-
their case, my lord.
No, Lordship-
Because they are saying they are not given marks against their experience.
We are given
In
0.
fact, they have not submitted experience certificate. There is no experience certificate. How the mark will given? Each year, SPO experience is 2 marks, maximum 10 marks. If he work as an experience as a SPO 6 years, he will get 10 marks, highest mark. If 1 year, they will get 2 marks. This is the simple thing, my lord. They are not submitted any experience certificate. This is their case. Why they are saying in another case, another case, another case? Let him establish it own case first.
Yes.
Acha, all right. Then Lordship may come to page 78.
Yes.
So this is the first petitioner, Vikas Bania. So Lordship will say here that no experience is SPO 0 in the down portion
Hmm.
of that page 78.
Yes. Yes.
So first contention is that Lordship, prima facie, this is something where an advertisement is called from the SPO. So I believe nobody can be 0. This is the prima facie thing. Acha, now
You're referring to which column?
page 78 from below, above total marks obtained. Above total marks obtained.
Experience as SPO.
Yes,
This is 0.
0. And Lordship will see document verification. Thus, just under the photo, in the same page, just under photograph, Lordship will see experience as SPO certificate submitted.
What certificate was that?
Yes. Now, of course, that is the bone of the contention ultimately, because that is what they're opposing. They are saying that the period of our work, of course, there is a certificate, but the period is not mentioned. And that is true. That is true on facts. But our contention is that now the other counsel, Mr. Mozumdar, had also spoken first. Now, what had happened on the basis of the same certificate where period was not mentioned, because this is given by SP. And we are people who are working as home guard. So at that point, of course, they could not even think of this level that where a period perhaps is not mentioned will not be ultimately counted. So on the where he had demonstrated in his case, of course, I could not get in my case that people who have submitted the same experience certificate were given up to 10 marks.
Where no date is mentioned.
Period is not mentioned. Date is mentioned when certificate is issued, but period from when to when. So that is true. That is not mentioned.
No, no.
If it is not mentioned, how they will calculate? 1 year, 2
You,
years?
are you submitting that other similarly situated persons
Have
who
been given
submitted,
marks.
who submitted similar experience certificates without there being any mention of the period
Yes,
have been considered and given marks?
that is our case.
We are denying it. We are denying it. Only one case they pointed out. I have filed affidavit. This was 78 lordship.
And lordship, later on, of
78.
course, the discharge certificate we did not have.
So all
but
these cases are all, how many petitioners here
30.
in this writ petition?
in this writ petition,
Oh, he has more than 6 petitioner. His case 6 petitioner.
6 petitioners
So all of them are disqualified on the same ground,
Disqualified.
on the same ground, yes.
no experience.
On the basis, one more thing, lordship will see that page 79, just the next page.
Yes.
This is Ghanakanto Nath. Now, Ghanakanto Nath has again been given surprisingly 2 marks based on the same certificate. One, Vikas Bunia has got 0, Ghanakanto has
No,
got
no, no. He's got 2 marks on the additional training, advanced training.
Oh, okay. That is, yes. Oh, SPO is 0, everyone.
Yes.
Then, lordship, we could later on, very recently, we could get the discharge certificate, not this common discharge certificate, which we have annexed in our affidavit in reply in this case. In affidavit in reply, if lordship comes to page 114, page 114 of affidavit in reply. So here lordship will see the following ex-home guards of different districts who were engaged as SPO in Kokrajhar district during the ethnic problem of 2012. However, as per direction of so-and-so, they are discharged from their service with effect from 15/6/2016. So from this discharge certificate, lordship, at least 4 years of
Page number 100 and
114, 114.
where is the discharge certificate?
Have lordship got this office of SP Kokrajhar 114?
No.
Affidavit in reply. Annexer M. No.
This is a discharge from service, my lord. Their service comes to an end. This is the person mentioned here in my lord, in district wide. This page 114, 114 is a discharge. They are discharged from service. They are no longer in the SPO.
You are referring to the affidavit in reply.
Affidavit in reply.
What is the paragraph number or page number?
Lordship, page 114, the annexure in affidavit in reply.
Annexure in affidavit. Yes.
Of course, lordship, this we could gather.
See,
later on.
when the matters are listed for hearing,
Yes, sir.
you are expected to consult, go and look into the court records so that the page numbers of the court record and your numbers are similar. So this 114 is your internal page number. In the court record, it is 174.
I'm sorry.
Which is why the matters are actually listed for hearing, so that the council also get time to correlate with the page numbers. A matter of this magnitude, I don't see why it is fixed for admission hearing. Yes.
So, lordship, here at least 4 years of services as SPO, it is established from this discharge certificate, and wherein the first petitioner's name is at serial number 15.
Okay.
So this is more or less the summary of our case. And
Now, what certificate did you supply? Do you have that certificate?
Yes.
Where is it?
is in the writ petition, lordship. It is page 29.
29. 29. Yes.
This is the certificate we had supplied, and our instruction is that all of us, because the people who are selected, they have also served along with us. And we are also, till today, we are serving as home guard.
So why do you say no date is there? It is there.
No, my lord, no.
You come to page 29.
29 years. This certificate is, my lord, only 2012.
Yes.
There is no more. And there is not speaking, even though they have given 2 marks here.
Huh?
Not given marks. They do not certificate, my lord. This certificate is not, my lord, experience certificate. They were, what happened, my lord?
Have you given a form of experience certificate? Have you
No,
described?
this is not experience certificate. But during the 2012, in the ethnic problem, Kokrajhar, Baksha, Dhubri, for that purpose, some home guard were deployed. Deployed does not mean they were engaged for duty.
Oh, have you seen the signatory of the certificate?
This is the superintendent of police.
So?
No, but this
Is it not, are they not under your department? Is it not for you?
Yes, yes, our department. Yes,
Is it a case that you have stated that this is a certificate interpolated, false certificate?
Not interpolated, my lord. My lordship, kindly see, my lord. This Sonitpur was engaged as a SPO in Kokrajhar district during 12 ethnic problem. Order dated, file order dated 12 of the Additional Director of Police, Assam, Guwahati, file letter dated so and so with professional commitment, devotion, and sincerity. That has been, my lord. Sonitpur was engaged as SPO. Actually, my lord, they were not deployed any work. They know this certificate, but this certificate should be contained. He was appointed as a SPO from so and so, so and so. He engaged SPO so and so, so and so.
That form is not given by the SP. Why don't you pick up the SP?
No.
Why don't you pull up your SP and tell him that how certificate
That's why, I'm not, this is not admissible, my lord.
Admissible under what provision?
Yes, yes. No, that's why I'm saying, my lord, there is no mention about the year, my lord. For 1 year or 6 months, 3 months, maybe 3 months.
2012.
12. In 12, my lord, ethnic, their problem is there, my lord.
What is the experience level that you want? 1 day, 10 days, 1 month?
1 year. 1 year for complete 1 year, 2 months. That is the advertisement, lordship, can you see?
Yes.
Page, advertisement, lordship, can you see? Page, my lord, lead petition. 15, no? Yes, lordship,
Page
can you see?
number?
Yes, page 35.
35.
35, lordship, can you see? May I read it? What is the purpose of this appointing? But this is 145. Recruitment of constable from SPOs. Actually, really, it is what this examination was done for the SPOs, those who were comes to end their services to engage, re-engage their demand. A sanction post against so and so. Recruitment relies will be conducted for selection of candidates for filling up 145 posts of constable in Assam. Industrial security force from SPOs, special police officer. Those who work in Dhubri and BTAD during 2012 ethnic problem. And SPOs who were deployed in the district of Bongaigaon, Sirang, Baksai, NC Hills for national highways so and so, so and so. Other the date of value so and so, so and so. And lordship, kindly see the breakup of the marks. Eligibility criteria is there. Next page, I think 50. Page. From 49, my lord. Page 49. Backup of the 18 number read petition. Backup of the marks awarded for extracurricular activities and special skill, which is maximum 40 marks, shall be.
No. What we want to see is what is that experience that you require?
Yes, I am.
Is it provided?
No, experience certificate. Lordship, can you see? Next 50 way. Experience as SPO will earn 2 marks for each qualifying 1 year. Lordship, can you see? This certificate does not say 1 year, 6 months of work from the how
No, each qualifying 1 year means each qualifying up to 1 year.
Yes, he will have to complete 1 year.
No.
No, my lord.
No.
This
That is
will
not
earn 2 marks for each qualifying 1 year. It will not exceed 10 marks.
No, but does it say below 1 year you are rejected? No.
Yes, below 1 mark they will not get it.
Where have
No,
you
my lord,
stated?
other successful candidate they have submitted like that, my lord.
Kindly see page number 40. Serial number Roman 4.
Yes.
This is the
40
certificate you wanted.
certificate or other document issued by the competent authority for deployment as a SPO in the Dhuburi and BTD during last 12 ethnic problem or deployed in Bongaigaon, Sidang, Baksa, notice so certificate. A candidate must
That's it.
possess
It
appointment
doesn't say
certificate
for certificate showing how many years and months of service.
or any other document for appointment as SPO is not eligible for applying for the post. And any other document for appointment as SPO is not eligible for applying for the post. The candidates should submit the copies of following documents. These documents are necessary. So explain in page 15, experiences, each mark each mallet only complete of 1 year, he will get 2 marks.
So
And
that
it-
is your interpretation.
No,
That is your interpretation. In
Accordingly,
the
they have-
advertisement, there is no specific requirement that that many years of experience is necessary.
But
The
it-
only experience necessary is deployment in those areas.
No, how they will then give the marks, mallet?
How they will give the marks is up to them.
That's why they have divided
We
it
can
by
understand you have given them 1 mark,
1 mark.
but
One
you've
year,
given them
1 mark.
0.
1 year, 2 marks. 2
All right.
years, 4 marks.
All right, so you give 1 mark, you give 2 marks.
No, Malad, he has no experience certificate, Malad, like that, Malad.
What do you mean experience? Whatever you
Experience,
specify,
Malad, from other person, Malad, I will have to produce.
they are home guards.
Yes, home
We are,
guard.
you are not,
But in home guard experience
Mr.
certificate-
Counsel, you are not seeking recruitment for PhD professors. You are seeking recruitment for special industrial force from
Constable.
home guards. The requirement
constable.
in the advertisement is for deployment under the ethnic violence. Certificate is issued by the SPO, SP of the district. You have means to verify whether these people were indeed working during that period or not. Could have verified from the SPs if required.
Malad, requires, but I will obtain certificate, those who have certificate accepted and given mark. I will obtain because I have received the instruction only because of these petitioners, those who are unsuccessful candidates. I will obtain it compared to
Now,
the
what is the cutoff mark? Is there any cutoff mark?
cutoff marks is total written examination is there and PSA 20 marks like that, Malad.
How much mark did they get?
In Malad, in the different district, different marks, Malad.
What is the select list? Is there a
Ultimately,
select
it comes to
list?
the state select list, Malad.
Where is the select list?
Select list, Malad, I think the select list. Today, Malad, I have not received the select list.
You have filed your affidavit.
We have filed everything, Malad.
So,
But let me have, Malad, this certificate and other certificate against those they have given marks.
you may adopt any criteria, but your criteria must be transparent.
Yes.
What for have you given an advertisement?
Yes, Malad.
Actually, one thing let me show, because there was no select list as such, page 91. That is how the result came online. Only our own result we could see. We could not see the whole list. Page 91. Only our own.
What is PET?
This physical test, physical efficiency test, and we had qualified for that.
Which says selected.
Selected, that part we were selected, and once again, Lordship will come to page 103. One portion, up to one part we were selected. 103 is the final result, again online, here not selected. Now we are afraid that because we were not given any marks for SPO, the total marks came down. So the total select list, we don't even know what is the total select, the complete select list. And therefore, exactly we cannot say about cutoff mark. Of course, they can say.
103.
103.
What does it say?
It say that we are not selected. Total marks we have got is 39, and marks obtained in extracurricular is 2. Of course, this is 2 because those marks were not given to us. It could have been more. Have our 4 years, 5 years was calculated, another 8 marks or 10 marks would have been added.
No, but how can they calculate when you don't provide?
Now,
In your
yes,
certificate,
yes.
there is no period.
No period. Yeah, that is true. That is true. But that is what we were provided, and that is what everybody was provided. Hundreds of certificates were issued like that.
Somebody else getting a benefit undue. It does not mean that the writ court is here to give you that benefit if not obtained, if not as per the
Lordship, if it is
procedure of
illegal,
law.
it is for everyone, Lordship.
You are here for your selection, not for everyone's
Of course,
disselection,
No, not for that.
deselection.
Not that. We don't want to harm anyone. Only
Then-
thing is that, Lordship, our due at least.
What
Well-
is the last number obtained by the, what is the,
I will obtain it.
Hmm?
Well, for the moment, page 78, Lordship can see.
78?
78.
Yes.
These are the format, my lord, how they are filling up after receipt of document. Document received from my lord, SP. My lord, because personal details. So and so Bonia, so and so mail, so and so. Document verification with original mandatory. As a age proof, caste certificate, SPN, SPO certificate submitted, result qualified. These are the document they have received, signed by the petitioner and signed by the.
what is
officer.
this qualified?
No, I'm not qualified. I will letter pass notice when it's.
No, first take us to the second column. This is document verification.
Oh, the document they have submitted.
They have submitted.
Yes, we accept or not accept,
Ye-
it is different thing.
Very well, but what is the meaning of result,
Yes.
qualified?
Yes, they have submitted. What they submitted, we have decided here, document submitted, so and so, so and so.
No,
And also, can you see next?
No, Mr. Counsel, be clear. These are your documents.
Yes, our document.
Kindly read the heading, document verification with original. So these are the documents which were verified.
These are ballot, what they submitted,
Hmm.
they are only accepted document. They have
Hmm.
accepted. And next ballot, Lordship, can you see physical standard test, the weight, so and so, doctor, so and so, qualified. And physical eligibility test. Physical eligibility test, he got scored 8 marks, qualified. Okay, to that extent. And physical eligibility test, long jump, so and so, 7 marks.
Where is the advertisement again?
Advertisement,
Starting from page 35.
in this case, they have already accepted what they have got it.
We want to know something. This is an advertisement, this is a special drive, isn't it?
Special drive.
Only meant for home guards and SPOs.
Home guard, they are actually deployed for SPO.
Oh,
Yes,
very
home
well.
guard.
Home guards
They
or
were
SPOs?
dropped after
We are
that lot
giving
of-
marks home guard also.
You are not giving this appointment to a person who does not have any experience.
Not for fresh people. Yes.
So it has to be a person who is deployed as an SPO or a home guard,
Yes.
right? Now, so at the time of document verification, if a person does not come with a certificate or certificate according to you, which satisfies the requirement, you are expected to reject him.
Yes, Lordship, can you see that, madam? This is page 78, madam, last person. Document verification with original.
Yes.
Extra academic achievement, so and so, marks, 40 marks.
Hmm.
Certificate, column, qualification percentage, 31.50%, 2 marks. Experience as a SPO, no experience as a SPO.
You are
0 marks.
skirting the question of the court. Please understand what the court is asking you. Kindly come to the second heading, document verification, page 78.
Yes,
Page 78, these are the documents required. Age proof, qualification, isn't it?
yes, my lord.
All these are approved. Again, caste certificate, experience as SPO. Now, if this document was not approved, was it open for the department to put him up for selection?
No, this document they have submitted, they accepted it, they have said
So
yes.
if you have accepted it, why are you rejecting
No,
it?
my lord, this certificate may be some other,
No, if it is some other, you cannot allow him to
they have
participate.
submitted a certificate as a XPO experience certificate. This may be accepted, may not be accepted because.
No. Your advertisement is for only SPOs and home
SPO.
guards,
A home
which
guard
you'll
also-
verify only on the basis of certificates.
Certificate.
So on the date of submission, if your certificate is not valid, you cannot permit him to appear. You have permitted and the remarks, the results say qualified. Kindly come to the last column, it says qualified.
Yes.
Qualified means what?
Result qualifiers means certificate is approved and
Exactly.
experience certificate is submitted. And that has been scrutinized later on, my lord. This is only for submission.
So you have permitted him on the
He
basis
has
of that
permitted him.
certificate.
Day after the final
No,
scrutinize.
no, on the basis of that certificate.
No, they will scrutinize later on, Lordship kindly
Why is
see.
the question of scrutinizing? This is document verification. This is the scrutinization.
This verification original.
Actually, these are all after the case was filed.
This will make them eligible for recruitment. Mark is different and recruitment is different. They will become eligible to be recruited here. That is why this certificate is there.
Good.
But for the marks, that is a separate issue. That is why the marks were not given.
No, my lord, that is why but I am submitting here. He has given caste certificate. He has given whatever may be certificate, SPO certificate that has been accepted. That column is filled up. That's why he qualified. That is the question. Later on, my lord, they will scrutinize. Their marks will be physical test, physical eligibility test. They will put their marks. Accordingly, they have, my lord, this has been made and no experience certificate, SPO 0 marks, total marks 2 marks. Later on, my lord, advance.
No,
total
which means that on the date when you are applying the marks, you have rejected the certificate.
No, my lord, they have submitted right away, but whatever certificate may be, their document submitted.
No, we can understand, I can understand that you have given 2 marks. According to them, they should get 5 years, 6 years, or whatever terms they've got, 2 marks for every year.
Yes.
We can understand that, yes, you have given 2 marks,
No.
considering it to be a service up to 1 year.
So far, document is concerned, they have submitted. They accepted it. And later on, I have carefully read all the entries regarding my performance mentioned above and accept the same to be correct. So petitioner put his signature, he has gone through it, my lord. We have how we are giving marks. But he did not object it.
How will you object?
So he could have said that, why no experience certificate mark is not given. Make any demo, my lord. Make any objection.
Why
No.
objection? He has come before the court.
No, but no.
Why should we? Why should we?
He could have objected.
Why should we throw him out on this ground that he did not raise an
throw him, my
objection
lord.
before the authority?
After competitive examination.
So
After competitive examination.
it is
my lord,
for you to. You have to disclose the procedure followed. What procedure have you followed?
Yes, I will update the records, my lord.
After you have filed the affidavit, matter is ready for hearing. You want to now complete your instructions by obtaining records.
No, I will have to go through to my lord. No, record no.
Yes.
I will obtain the records, my lord. I will go through it, my lord. I will clarify this position, my lord, why it is qualified. What is their stand?
At the same time, counsel for the petitioners, we have not challenged the selected candidates. Mainly because some posts are vacant. After 7 years or 8 years, why should we issue a writ? Even assuming you have some merit in the case.
If select list was not published, we could not even get. I have shown how the result was.
You
given.
have not got because you have not approached. There are various laws under which you can apply and find out what is your status. You choose not to. You want to come to the court, issue a direction to get the records so that you can peruse and it's comfortable for you. What is your right that after 7 years or 8 years, the selection has to be interfered with? That too without arraying the selected parties.
Lordship, first of all, Lordship, our instruction, of course, it is not a perfect instruction. Instruction is that some posts are still lying vacant because of this case.
No, that is a different issue. Some posts may be lying vacant, not vacant. We are not concerned. You have challenged the selection process.
Yes.
But you have not arrayed the candidates.
That ought to have been.
Then? Yes, any other petitioners? This is the position on facts. You have not arrayed the selected candidates. Why?
That time not collect the Lordship select list.
Huh?
Not collect the select list, Lordship. It was also applied in the RTA Act, Lordship. It is also not furnished, Lordship.
Even, my lord, at that point of time, the rejection slip has been given, and only the person concerned who can obtain the rejection slip in his own
the selected rejection slip cannot be downloaded from the internet. But entire select list has not been published. I have stated in my petition. We have tried to procure the same, but could not procure.
Yes, Mr. Sutia, you show us,
They have given the personal rejection slip.
assuming one particular mark for 1 year is applied, what will be their position
Yes. I will
vis-a-vis
see.
the last selected candidate?
Yes, I will see, ma'am. I will see, and I also try to obtain, my lord, the experience certificate against whom they have given marks.
Lordship, in item number 35, even in the written test, Lordship, proper marks were not given.
So all the writ petitioners, their only grievance is that
Same, my lord.
experience certificate, no marks given.
No marks is.
No marks given, and even the, it was same certificate submitted by other, I have annexed there, that given 10 marks for home guard, and the same certificate given by the petitioner given 0.
My lord, in home guard, we have given marks. Lordship, can you see item number? And for timing, 14. 14. Zahirul Islam, my lord, repetition number 3763. For the timing, my lord, Zahirul Islam, we have given marks. Lordship, can you see? 3760. Zahirul Islam.
3763, item 14.
Item number 14. Item number 14. This one also. More than 3760. File to item number 14 no. Yes, Lordship, kindly see page 20.
1 minute.
For example, my lord, I am giving.
Yes.
Page 20, Lordship, kindly see. There is come to Lordship. Page 20 is a certificate, my lord. This is a certificate commandant issued. But he got marks here, 10 marks, my lord. Has appeared before the selection committee on so and so 2020 and being found physically, medically fit and to work home guard for another period of 3 years. He has already served 3 years in the service. The selection committee accepted and recommended his name to the commandant general so and so for under period of 3 years with effect from 1/1/2022 to 31/12/2024 as per provision of the Home Guards Act. So this certificate he against this manner we have given marks. We have given marks, my lord, 10 marks because he served for 10 years, my lord. 1 year's home guard as a my lord, one mark. This certificate is specifically is mentioned really 3 years, 2 years, so this is a my lord experience certificate. They have given only deployment certificate. They were deployed in the so ethnic group.
So why did you accept their papers on the verification?
No, my lord, verification. Any
What
document
purpose?
they have submitted, assuming they are as per their my lord, this is a experience certificate. They accept it. Therefore verified.
So if you accept, then you have to
No,
consider.
my lord, accepted it does not mean that they have given marks, my lord.
No.
Marks
So what else is it necessary?
No, necessary, my lord. This
The
certificate.
whole selection is meant for the special police officers and home guards.
This
So
cer-
on the to find out whether he falls in the criteria or not, you have accepted the certificate given by them.
So
once you accept, you are expected to give some mark. If the advertisement provides, which it does.
No, advertisement says what documents are required. Accordingly, they have submitted.
Advertisement doesn't say that these must specify the number of years you have served.
No, my lord, that has
Doesn't
been,
say so.
that has been break up.
Then
This certificate, my lord, shows this certificate he got, my lord.
yes, when can you get your instructions?
My lord, after 2 weeks, my lord.
Why 2 weeks is necessary?
My lord, I would have to bring all this record. I have to consult with the officers, my lord, to clarify all these things, my lord.
Heard learned counsels for parties, Mr. T.C. Sutia, additional senior government advocate, submits further instructions are necessary and also the relevant records which may contain the select list is required to be procured. He therefore prays for 2 weeks' time. Counsels appearing for the petitioner does not object to the prayer made. List these bunch of petitions after 2 weeks. On a date to be fixed by the registry. Yes. After 2 weeks.
Retain mark, one of the photo cases was retain. Retain mark the application photo case. Photo case. 35. 35.
Yes. Next matter.
Obliged.
Item 36.
35. No problem.
My lord, in this case, my lord, leave salary and my lord, area revised pay of the person has not been paid despite of the order of this honorable court, my lord. Kindly say, my lord, order date 1905.
Yes, respondents.
My lord, as far as the prayer is at page 21, my lord, there are two components to the prayer.
Last order says you are permitted to obtain instructions. Have
My
you
lord, I
received?
have received the instructions.
Okay.
As far as the question of leave salary is concerned, at page 21, my lord.
Yes.
So the first component that he's seeking is the leave salary, 7,63,000. As far as the leave salary part is concerned, my lord, the department says that he is not entitled to the same, as there are no leaves in his credit, my lord, standing to his credit. So he cannot be paid that particular amount, 7,63,000.
Have you filed your counter affidavit?
My lord, I have not filed.
You have to file. You have to bring it on record so that he gets an opportunity to rebut.
Yes, my lord.
What about the second part, area?
Look, as far as the second part is concerned, the department commissionerate has requested the BDO to submit a fresh proposal for the financial year 23-24. They had submitted it for the year 22-23. So a fresh proposal is yet to be received from the BDO, wherein the petitioner was working prior to his retirement. So once that is received, that will be paid. Or my lord may dispose of this writ petition with a direction to the commissionerate to verify all the claims pertaining to the petitioner and accordingly make.
No, but you are rejecting his claim for leave salary.
Leave salary he is
Then-
not entitled.
Then you'll have to bring it on record.
I'll file the affidavit.
You bring it on record.
I'll bring it on.
Mr. R.S. Vaughan appears for the petitioner. Mr. Hendick, appearing for the PNRD, submits that as per instructions received, petitioner's claim for leave salary is not maintainable. However, the revised area salary, revised area pay with effect from 1/4/2016 to 28/2/2017. Can be examined by the department, and if entitled, the same can be released. Stop. What do you say? He says your leave salary is not available.
I have to take instruction, my lord.
Let these instructions be brought on record by the respondents within a period of 2 weeks from today. List the matter after 2 weeks. Mr. S.K. Medi for
Accountant.
accountant.
Obliged.
Yes, you prayed for an adjournment, but what are these matters? 2013 matters?
See, Lordship, without Mr. Somoa, it is not possible to argue, Lordship.
What is this matter about? Tell us.
Lordship, it is the matter of, Lordship, the village, Pachim Dhuli,
Rabahasong.
Rabahasong, Lordship, they have to include this village in the Rabahasong Autonomous Council, Lordship. If they include this village under Rabahasong Autonomous Council, the villagers will face some problems, Lordship.
Now, yes, who's for the respondent? Pleadings are complete.
Pleadings complete.
Question number 4. Ito আপোনালোকৰ affidavit খন কেইখন পাব?
Yes, Mr. Dhor.
My lord is taking up this matter, my lord. My lord.
We would have liked to take it up, but there is a prayer for adjournment,
My lord, my lord. My lord.
which I'm sure you'll readily agree. Yes,
Next week or any day, my lord. My lord will take.
a prayer is made on behalf of the council, Mr. H. Omoa, that is out of station, who represents the writ petition, as in all the writ petitions.
Lordship.
Same is not objected to by the learned standing council, Mr. R. Dhor. Matter stands adjourned for 1 week. Same order. 1 week.
Blank.
May I please wait? Also, the issue involved in this petitions and similar issues are pending before the Honorable Apex Court. On last occasion, this court direct us to find out the status of the present status of the case pending before the Honorable Apex Court. So only we have only this much of information we have on. Last listed on 2019, April 2019.
What is the status, Council for Coal India? Any updates?
Yes. We have also informed that the matter came before the Honorable Supreme Court on in the month of April.
Okay.
When?
What is the,
April 2019.
what is the issue here?
That here excise duty on coal reality imposed.
Coal India has issued some debit note, for the sale, which have already for a retrospective sale, lordship.
With effect from the 11.
Okay.
11.
It is submitted at the bar that the issue involved in this matter is pending before the Apex Court in Civil Appeal numbers 1074 of 2018 in so-and-so versus so-and-so. And the matter is presently pending disposal before the Apex Court. Accordingly, in view of the submissions made, this bunch of writ petitions stand deferred for another 6 weeks.
I look.
After timing, my lord, after some time.
After some time, okay.
This will look at OBP teacher of Nadira subdivision.
Huh? Yes.
OBP teachers of Nadira subdivision, they were initially appointed, lordship will find, they were appointed serially in 1995. Page 21.
There is an order earlier that it should be listed in part 2. I don't know why this matter was not.
Because look, some of the petitioner has already retired from service.
No,
And
maybe, but this order is there.
and lordship may fix this matter on a hearing there for final disposal.
Today is a hearing day. Every day is a hearing day.
I'm
What
ready,
is,
Lordship.
what is the matter about?
I'm ready, Lordship.
What is the matter about?
Petitioners were appointed as the OBB teacher. Subject to pass of Lordship, the basic training center, their service will be regularized. They have completed the basic training. Page 21 is the original appointment order of Mahendranath Mohanto, Lordship. Page 21.
21.
Page 21.
Yes.
Subject to discharge without any notice assigning a region thereof, Mahendranath Mohanto village, Utpari, Patra, Upper Nazira district, appointed as secondary teacher, posted at the Rajpari Primary School following terms and conditions. Initially, she will get monthly stipend of rupees 900 only, and subsequently he will be deputed for undergoing training for 1 year subject to availability of seat. After successful completion of training, he may be allowed to draw regular pay scale after approval of the district elementary education minister, Assam. He cannot succeed in the training, he will be allowed to appear second time as private candidate for which no TADA will be paid. EC cannot came out successful in second chance. Service will be terminated without period of 1 month from the date of announcement of the examination results for which no claim appeal will be entertained. This is the original appointment. Lordship, thereafter petitioner has completed junior basic training, page 23. He has completed junior basic training, and thereafter, Lordship, petitioner has been given regular scale of pay. Lordship will find page 25. A regular scale order. In pursuance of Director of Elementary Education Assam, Kahiripara, Guwahati 19, Mahendranath Mohanto, secondary teacher of Rajapara LP School under Deputy Inspector of School Nadira, who has passed the junior basic training exam on Iman, as per directors, has been hereby allowed to draw regular scale of pay and government admissible allowance with effect from 12/6/2001. Lordship, got it.
Yes.
Arrear salary will be paid only after receipt of budget purpose, and he will enjoy the above salary from the current month from existing budget. So, Lordship, all these petitioner has completed junior basic training and they are paid regular scale of pay. Now, the government has also filed an affidavit that petitioner has been paid salary up to 2016. Hereafter, Lordship, this salary has been stopped and 2 petitioner has already retired from service.
Yes, who's for the respondent?
Lordship, Mr. Khatuniar is on his way, Your Lordship. He's coming, Your Lordship.
We'll have it at 2 p.m. Let us find out. Yes, 2 p.m.
Already, Lordship is aware, Honorable Justice Borua has passed a judgment regarding this stipend and OBB teachers, and who will be get the pension and other things that has been decided. And according to that, Lordship, some cases were disposed of. Here also, Lordship, 2 petitioner has already, there is the order from this Honorable Court.
You point out at 2 p.m.
Lordship.
We'll take up.
MSCPS matter, my lord. Grant of MSCPS. Any
All
date,
right.
any date, my lord.
We are not fixing a date. You want an adjournment, you take it.
Pass over the
Matter is adjourned at the request of learned counsel to the petitioner.
Okay.
Mr. A.K. P. Purukashta. Yes.
By the submit, Lordship. Petitioner were originally appointed on a fixed pay of as a stipend teacher in 1995 in Nadira. Subject to completion of junior basic training, their service, they will get regular scale of pay. That was the initial appointment. Lordship, find at page 21.
21.
Page 21.
Yes.
Type copy, Lordship, page 21. And
Yes.
original copy at page 22, Lordship. Lordship will got that without subject to discharge without any notice assigning a region thereof Mahendra Mohanto, village Utpari, Patra, Upper Nadira district, here appointed as a stipend teacher and posted in Rajapur Primary School following condition. He shall get monthly stipend of rupees 900 only per month. Subsequently, he is deprived, deputed for undergoing teacher's training, 1 year subject to availability of seat. After successful completion of training, he may be allowed to draw regular pay scale after approval of the Director of Elementary Education Assam. If he cannot succeed in the training, she will not appear a second time as a private candidate, at which no TAD will be provided. If she cannot come on successful in the second chance, service will be terminated within a period of 1 month from the date of announcement of the examination result, for which no claim appeal will be entered. Original copy at page 22. Thereafter, Lordship, he has completed basic training. Page 23. Mohendra Mohanto has passed Assam Junior Basic Training held in the month of 2000 under Director of SCRT Assam, Guwahati, and placed in Simple Division. Result declared SCRT Iman. Hereafter, Lordship, his service has been regular. Original page at page 24. That is certificate by BTC Shivsagar. Principal BTC Chunari Shivsagar. Page 25. Page 25. Lordship, got it. After passing of the junior basic training, petitioners were given Lordship, regular scale of pay with effect from 31/2002. Lordship. In pursuance to Director of Electrification Assam Kahilipara, Mohendra Dutt Mohanto, teacher of Rajapul LP School, under Deputy Inspector School Nazira, who has passed junior basic training examination on Iman, as per Director, has been allowed to draw regular scale of pay as government admissible allowance with effect from 12/6/2001. The arrear salary will be paid after receipt of the budget for the purpose, and he still enjoy above salary from the current month from existing budget. Thereafter, petitioner was getting regular scale of pay.
Yes.
Lordship, there are altogether 14 petitioners. All the petitioner has completed junior basic training. I have enclosed thereafter, Lordship, the appointment order and the junior basic training certificate and regulation order. All the 14 has completed junior basic training. They agree regular scale of pay.
Yes.
All are stipend teacher, Lordship. Fine. From the initial appointment, they are stipend.
Are you covered by their judgment?
Lordship.
You are covered by their judgment. So,
And secondly, Lordship, some in cases, some of the petitioner, they are regularized page 40, Lordship. Pursuant to Director, page 40. Some of the petitioners is a common order regarding regular scale of pay.
yes, respondents, what do you say?
We have filed our affidavit, my lord. Our basic stand is that though petitioners were appointed as stipendary teachers, my lord, their initial appointment was, according to us, my lord, illegal, my lord. Their initial appointment was against non-existent post. That is why their appointment have been termed as illegal appointment, my lord. Subsequently, they have been subject to a screening process. In 2010, there is an order from this honorable court to identify those illegal and irregular teachers, those who have appointed in the year 89, 91, then up to 2001. They have been appointed during that period. So in that screening process, my lord, they have participated in that screening process. And during the evaluation, my lord, it was found that they have been appointed against non-existent post without any selection process. So finally, cabinet took it, but they are continuing in their service. There is no dispute that they are not continuing. They are continuing. So subsequently, cabinet took a decision to regularize those employees who have been continuing in their service from the date of their appointment. So accordingly, with prospective effect, according to their qualification, some were accommodated as teacher. If they have the requisite qualification, they have acquired before 2011, and those doesn't have the junior basic training, they have been accommodated as tutor, my lord. So here, I have mentioned the name of the petitioner who have been at paragraph 13, my lord. Paragraph 13 of my affidavit. Page 175, my lord.
Yes.
The answer is humbly begs to state that out of 14 petitioners, 3 numbers of petitioners, namely Rontumoni Khonikar, petitioner number 7, Mohendra Gogoi, petitioner number 10, and Sudarshan Prasad, petitioner number 14, have been appointed as newly accommodated teacher with prospective effect on the basis of cabinet approval dated 7/10/2020.
Page number?
Page, my lord, internal page 9 and continuous page, my lord, 175.
175.
Yes, my lord. Internal page 9, my lord.
Approval. That part. Which one?
The
A and B.
13, paragraph 13, my lord.
13.
That page, my lord, paragraph 13.
Yes.
Out of 14 petitioners, 3 numbers of petitioners, namely Rantumoni Khonikar, petitioner number 7, Mohendra Gogoi, petitioner number 10, and Sudarshan Prasad, petitioner number 14, have been appointed as newly accommodated teachers with prospective effect on the basis of the cabinet approval dated 7/10/2020. In respect of the Sri Mohendra Nath Mohanto, petitioner number 1, and Sri Chittaranjan Borgohain, petitioner number 2, though they participated in the screening process and fulfilled the criteria as laid down in the cabinet memorandum and identified as irregular teacher, however, they could not be appointed as newly accommodated teachers since in the meantime they have attained the age of superannuation on 30/4/2020 and 31/5/2019. So they have been given fresh accommodation with effect from 7/10/2020 from the date of cabinet approval. But these 2 petitioners, they have retired in the year 2020 and 2019, my lord, before the date of cabinet approval.
What was the cabinet decision?
Yes, I have annexed with this affidavit, my lord. It is Annexer A.
Please read. And read from para 2.
Here, well, the instruction is annexed, well, not the entire cabinet approval, well, but the basic approval is extracted here, well. Paragraph 1, well, that in compliance of the Honorable Court final order dated 2/3/2010 passed in WPC number 1048/2004, the Education Department placed the matter for a matter of regulation of irregular teacher before the cabinet in its meeting held on 26/2/2011. Thereafter, the Education Department proposed the constitution of screening committee to examine the cases of these teachers. With a view to examining the selection procedure, the name of appointment, nature of appointment, status of post, working status of salaries, academic qualification, etc., the Director of Elementary Education, Assam, invited application from these illegally appointed teachers during 1991 to 2001 throughout the state by an advertisement dated 1/2/2012 and 4/2/2012 in local newspapers. In response to the said advertisement, applications were received from such category of teachers. After conduct of preliminary examination at the directorate level, Elementary Department constituted 5 screening committees headed by the divisional commissioners concerned and principal secretaries of the 6 scheduled areas and BTCs to examine these applications. Then a committee was formed by the government in Elementary Education Department to verify these materials. This committee prepared 3 lists based on screening committee reports. The list 1, my lord, the teachers who have received salary up to 2007 and onwards and having junior basic training or DLED are included in list number 1. List number 2, the teachers who have received salary up to 2007 and onwards and not having junior basic DLED are included in list number 2. And list 3, my lord, who have neither received salaries nor having prescribed training.
These people fall under list 1.
List 1, my lord.
They fall under list 1.
Yes, my lord.
So list 1 gives them what benefit?
They have been accommodated as teacher, my lord, because they have the required qualification.
Except for the 2 petitioners.
Yes, my lord.
Who had retired in the meantime.
In the meantime, they retired, my lord. As regards the other petitioner, my lord, petitioner number paragraph 14 in the affidavit, my lord. Remaining petitioner, there is Ajit Kolita, petitioner number 3, Omulya Datta, petitioner number 4, Kamal Bailung, petition number 5, Raju Kumar, petition number 6, Lokeshwar Das, petition number 8.
When the screening took place, or when the cabinet decision took place?
Cabinet decision matlab 7/10/2020, madam.
7/10.
2020.
Now, you had received salaries up to which month?
Up to 2016.
16.
Up to 2016, we have salary. Up to 29 to 16.
And you also have the basic training. Now they are accommodated as teachers again.
Teachers again.
Fresh order.
Fresh order, madam. With the prospective effect, madam. From the date of approval of cabinet, madam.
My submission will also. What they are saying, they are continuing its service. They have not been terminated. My submission will also. They have not paid the salary from 2016 onwards till date. And some of the petitioners returned from service. They have not been paid salary till date of return. But they have been released in service. And this honorable court, Lordship, ultimately two petitions.
Have you challenged this order?
Lordship,
The screening committee and the inquiry done and all that, have you challenged it?
that has not been informed to us till date, Lordship. That was the communication of the affidavit.
This is the part of the affidavit.
Lordship, this is the affidavit. Only thing is, Lordship, my submission will also. Two petitioner has returned from service in the meantime. And
Somehow we are not being able to, I have not been able to convey. You see, you are claiming area salary on the ground that you have received till 2016. Thereafter, although you started work, you have continued to work, salary has not been granted. Respondents have taken a stand that they're all illegal, irregular appointments. However, in view of the cabinet decision, a committee is constituted whereby all these appointments, illegal or irregular, are looked into. Committee has classified 3 lists. You fall into the first list, which is salaries received up to 2007, in your case up to 2016, and having JBD and DLED degrees. And since you fall in this first list, you are given an appointment order.
Fresh appointment order.
Fresh appointment order. Now, in that view of the matter, the very fact that there is a finding by the committee that your appointment was illegal or irregular, where is the claim for a regular salary?
In this regard, may I submit one? Page 169, page of details report.
You have accepted the appointment.
We have filed affidavit in reply to the affidavit filed by the government. We have given a reply. What they have stated earlier to these honorable.
No. Pursuant to the order passed by after the screening committee, have you joined in your services? Or have you accepted that order? Mr.
Yes, well, they have accepted, madam.
Where is it evident?
In fact, in their affidavit, my lord, they have stated.
Reply.
Reply affidavit. I have seen, my lord, somewhere.
Also, will kindly consider one thing. What has been paid in this petition? We have been Lordship, the NB state with the access system of Nazira subdivision for stopping our salary. That has been reflected at page 235 of the affidavit of Lordship, we can say 235. That is a submission report by the Deputy Inspector of Schools, Nazira, page 235.
whatever it may be, but our screening committee considered your case.
Screening committee considered our case. We have been asked to submit the documents regarding our appointment.
What,
regarding-
then you are placed under list one,
That is also after filing about this petition.
whatever. So now the position is that you are considered to be irregular, but having received salaries up to 2007 and having the basic degrees, you are now um, given the fresh appointments. Now, this fresh appointment has come pursuant to the screening committee, which is pursuant to a cabinet decision to reconsider the cases of the teachers who are illegally or irregular appointment, which means that there is
Report. There's
a report at some level that you are illegally or irregularly appointed.
That report itself has not been communicated to us till date also, that we are illegally or irregularly appointed.
You have
Now
accepted.
only affidavit has been filed, that report has not been annexed till date also for challenging. We have also filed application under RTI Act to obtain the report. That was also not provided to us. How can we challenge those
Where is that
report?
appointment order?
Fresh appointment order.
Huh?
That I will bring it on record, my lord.
No, merely bringing it on record will not do. You'll have to tell us whether they have joined or they are still working pursuant to the fresh appointment, salaries received, etc. This writ petition is prior to the cabinet decision.
Yes, my lord. It is prior to the cabinet decision.
So once you have accepted the cabinet decision and the subsequent, what is to be?
The cabinet decision, what cabinet decision has stated, Lordship,
Hmm.
before that, this honorable court has given pass an order, common order.
Hmm.
Honorable Justice Borua has passed an order.
Hmm.
The stipended teachers who are working, who have gained the basic training, they are entitled for the general pension scheme. That has been decided by the court. And thereafter, Lordship, in this phase of writ petition, earlier writ petition, writ appeal was also filed. Our petitions were allowed, directed by the government, directed to pay the salary and everything, Lordship, with immediate effect. There is an order we have annexed that this court has directed. Now they will take a fresh decision, one bath or one other. Ultimately, how petitioner will get their salary, Lordship. Already there is a direction from this honorable court.
Where is that direction?
Lordship. Lordship will find page 134. Page 139 is the 11th question, para 7.
130?
9. 11th question, para 139, para 7.
139.
139, para 7.
Yes.
Taking consideration of the totality of the circumstances, it is hereby directed that the arrear and dues with effect from 1/12/2009 to 30 April 2010 shall be paid by the government to the concerned and all other teachers within 1 month from today, and the government and the officers shall ensure payment of the monthly salary teachers latest by 15th of each succeeding month. Respondent number 2 to 7 hereby forwarded that if these directions are violated by them, then they would be exposing themselves to the serious consequences, including contempt of proceedings. So this order has been passed in the writ appeal. Hereafter, Lordship, our salary has been paid up to 2016, and now they have stopped. Again, they make an inquiry. Everywhere they will make an inquiry and say that we are not.
You subjected yourself to that inquiry.
Lordship, they have conducted an inquiry.
Huh.
They have conducted an inquiry. Before that, Lordship, the Honorable Justice Borua has passed an order directing the covered by the stipend teachers are getting the regular scale of pay, and they should be given the pension also. Acha, acha. Out of field.
Yes.
Look, these are judgment passed by this honorable court in WPC 6403 of 2021. Lordship will find page 406, 409, para 118.
No, where is the finding regarding the
Appendix para
stipendary
118.
teachers?
Para 118. One looks it. Writ petitioner who come under the fold of 70 teachers and entitled to benefit of Rule 1969, they are also not covered under NCPS 2009. Petitioner also entitled to subscribe GPF. Said petitioner also entitled to all other pensionary benefit to which government servant is photogenic rank is entitled. Now they will make an inquiry one after one other. They will say lots of different things.
No, you, where is the finding with stipendary teachers? Paragraph
Lots of
22, page number 329.
lots of. We are appointed again sanction post also. May I place one thing, look. May I place one thing? Kindly see page 140 of the report. And except 20.
What is your prayer in the writ petition?
Prayer not to include us along with the access teachers who were appointed without any post
In this writ petition,
Lordship.
WPC 6435, what is the prayer?
Prayer is simple, Lordship. Upon the premises, it is therefore prayed that your Lordship may graciously please admit the call for a record to a rule following up the response so caused. As to why direction will not be issued for permanent detention of the petitioner and delete the name of the petitioner from the list of excess teacher of Sibsagar district, as to why direction will not be issued to pay current salary as well as arrear salary from March 16 till date of filing of this petition. May I take a look?
And what is the ratio of the judgment?
Ratio of the judgment, Lordship will kindly see the stipendiary teachers who were appointed before 2001 to 2005. They are entitled to.
Subject to correction, ratio of the judgment is whether they're entitled to pension or not.
Yes, Lordship.
The issue in the writ petition is not with regard to
No,
pension.
no. Because
Then why are you pointing out the
already,
judgment?
Lordship, no, I have, according to them, what they are submitting, that is why I have to place the judgment. My submission to be, Lordship, we have already filed separate writ petition of the two writ petitioner who has retired from service. And there is already direction from this honorable court to give pension to us. Already contempt
On which direction?
direction from this honorable court to give pension to the writ petition.
Which order? Which order?
No. In this writ petition, it was filed in, Lordship will find this writ petition has been filed in 2017. After that, two writ petitioner out of this has retired from service. They are not getting pay. They have been released from service after attaining the age of superannuation. We have paid that we have a GPF account. We should be given the pension immediately after that. But they have not released pension, not gratuity, not provident fund. We have approached this honorable court by filing a separate writ petition for a direction that our financial benefit as per pension scheme should be released. And this honorable court already directed to give pension to the.
Where is that order?
That order, Lordship, I can give. Immediately I can give. That writ petition already there is direction to give pension to the two writ petition.
Now?
Now, Lordship, contempt petition is pending, they are not paying.
No, in this writ petition, what is your prayer? For
My
release
prayer
of
is-
arrear?
My prayer is, Lordship, not to include us along with the excess discharge.
That
of-
has already been done.
No,
That exercise
not
has
done.
already been done.
Not done. That is why I will place, Lordship.
Ah.
Page 20, Lordship, kindly say page 20.
Yes.
It is similar.
20 is your
appointed in
affidavit.
Same beds.
Huh?
Page 20, 140, page 140, annexer 20. That is a communication from the Deputy Secretary Government of Assam to the Director of Education Assam regarding release of monthly pension of Gopal Kolita, one of the person who has been appointed the same process. With reference to the above, I am directed to say that from our record, it reveals that post held by Gopal Kolita was brought under non-plan, post creating post non-plan, height letter number Iman, in incumbency and least communicated height associate letter. Name of Gopal Kolita is listed, serial number 257. Subsequent to DIS, Nazira has submitted a proposal for permanent detention, 610 LP post and Nazira subdivision height later dated Iman. Name of Gopal Kolita was enlisted at serial number 37. But to certain reasons, posts were not retained permanently. However, temporary retention was accorded, issued annually. The last temporary retention was issued on Iman. In view of the above, the DDO Sibsagar under number Iman is forwarded height letter number reference appears that not based on facts, Gopal Kolita should not be included with the 13528 access teacher under Sibsagar district at any point. And hence, under no circumstances, monthly salary of Kolita should be stopped since posts are already retained up to 29 to 2012.
He is the petitioner here.
He is not the petitioner.
Ah.
He is appointed in the same beds of writ petition, same list, permanent retention. Retention order, Lordship will find.
No, this is not the way to proceed in the matter. Your prayer is something else, you're arguing something else, you're
No.
referring to some other
No.
benefits.
No. Why?
Your case is considered in terms of that cabinet decision or not?
No.
What is this? What is the position?
My lord, kindly see in fact, their prayer for salary was rejected, my lord. I have annexed that order also in person to the cabinet decision. Annexer B, my lord, annexer B of my affidavit, my lord.
Without challenging the High Court's order, Lordship, how they can say they will not pay salary?
Annexure B.
B.
Yes.
That is the order, my lord.
This is pursuant to the contempt. Some contempt petition.
Yes, my lord. But
The contempt petition is pending.
Pending.
What was the direction in WPC 2677?
2677 is regarding lordship area amount pension, area amount of salary as well as pension. I'm giving lordship copy.
Area? What is the prayer here? 2677.
Lordship. I'm giving copy lordship. Directed to give provisional pension. Lordship.
This writ petition is not listed today. Then you get these matters listed together. They filed by the same petitioner.
Two writ petition.
Two writ
Amount
petitioner.
of 14.
All right. But both of them are petitioners here.
Lordship.
Uh,
Before that, may I please lordship?
Now,
Order.
this 1 minute. This order, this was passed when? On 21.
21.
This order was not considered here.
No.
In your
No.
was it communicated?
Communicate.
It doesn't find reflection here. It is. Yes.
in fact, in the first paramal, it is reflected. Peruse the order is so and so.
There are a series of writ petition, lordship. I have annexed the order regarding Nazira subdivision. Again, lordship 150, saying the excess teachers were taxed with us.
This is the finding. You are not recommended. Although appeared. That is the department's view.
But only thing is, lordship, we have filed application at the RTA Act to give the copy of the screening committee's report. Without that, lordship, we cannot challenge that. But our order are there from its honorable court, High Court order, that has not been complied with, and they are giving some screening order and other. Lordship will kindly see before that, lordship, page 150, order of its honorable court.
You challenge that order because I do not think without putting to
Understand.
challenge there is
Understand.
any relief can be granted here.
Understand.
What relief can be granted here?
Here we have prayed. What we have prayed, lordship, we should not be.
Whatever you have prayed has been rejected. You have prayed for arrear. That is rejected. Rightly, wrongly, they have rejected. Now you are entitled to assail that order, which you have not done. You have not done.
May I request, Your Lordship, they may be provided the screening committee's report, otherwise you cannot. We have filed RTA
You
application.
provide them a screening committee report. Why are you keeping it under?
No, my lord. Whatever is with us, my lord, I can give it.
Give it. Give a screening committee report. You should have uploaded in your website.
What we have prayed, Lordship, that has been decided by this honorable court. After that, Lordship, they are constituting screening committee and other things. Lordship will find at page 150, order of this honorable court. 150, Lordship. Honorable Justice Bhaipe has passed this order. Lordship will find at page 157. The letter I have shown regarding Lordship. We are incumbency of list of 610 teachers, but they want to include the access teacher. Page 157 is 11 portion. In middle portion, Lordship. Lordship will find that district education officer Sibsagar to release salary of similarly situated person like one in Gopal Kolita, what I have shown already. Lordship. Assistant teacher of 176 Pupramama, Sibsagar district, whose name also appeared in the incumbency of list of 610 teachers prepared by the respondent of 7. In fact, respondent number 2 directed disciplinary education officer to inquire how, said, and for whose fault name of the teacher has been enlisted among the 1528 of access teachers of Sibsagar district. Thus, one fact so found by me, the inference is irresistible and conclusion and inescapable that petitioner herein have been subject to hostile discrimination, are illegally and arbitrarily denied their current and arrear salary legitimately due from them with effect from March 2011. Law is now well settled that financial constraint cannot be a ground for the state which is said to be model employer to deny. For what has been stated following, writ petitions are allowed. Respondent authorities are directed to pay the current salaries of the petitioner within a period of 1 month from the date of receipt of the judgment. They also release the arrear salary of the petitioner within a period of 3 months from the date of receipt of this judgment. These are the judgment laws. These have been not obeyed. We have been included along the access teacher. There is a permanent detention. You will find permanent detention order. Permanent detention order. You will find page 122.
No, everything is all right except for the fact that you have not put to challenge the order
Screening committee's report.
That
We have
is to
not
be
copied
challenged.
it. We have filed RTA application also. We have not been provided.
The RTI, if it is not provided, you have an appellate forum. You should have gone in appeal.
From 2016, they are not getting any salary.
No, they are not getting
Nothing, Lordship. They have
unless, Mr. Counsel,
I understand, Lordship.
you have to, you are an astute counsel, you must argue on legal issues. You are arguing 3 writ petitions at one go with different prayers. The prayer here is very simple, arrear salary. Prayer in the stipendary, which you pointed out, which you referred, is for pension.
Because Lordship, they have said that they are not giving this pensionary benefit. That is why 2 petitioners are rejected from service.
No, retired from service, provided their services have been held to be legal, only then they will be entitled to pension.
And already this court has held that our service is regular in different writ petition.
In this writ petition, were you a party? This WPC 870.
870, Lordship.
Hmm?
We are not made party, but we are party in subsequent writ petition. Lordship will find page 145, where 870 has been discussed. Page 147. It starts from 145.
No, but then that order should have been challenged. Screening committee order.
Page 147 is the relevant.
There is a clear averment that you are placed in the list 1. This affidavit was filed more than a year back,
No, no, no.
almost a year back,
This affidavit has been filed
10th of April,
7th of April.
almost a year back.
10th of April 2023.
Hmm.
We have filed reply on 2/9/2023. And where we have enclosed the letter of the inspector of schools, page 235, where it categorically stated that we have been enlisted with the access teacher. And salary has been on rotation basis with the access teacher. Page 235 is the letter of the.
No, but
inspector.
unless the order of screening committee is there, what orders do you want the court to pass?
Let them look to produce the give the copy of the.
Where is your RTI application?
That is not annexed here. Because it was a 2000 earlier.
It is for you to acquire this information, not for the court. We can close it, or you want to withdraw it, we'll give you liberty.
We'll file a separate declaration. Let's keep it pending.
Why should we keep it pending? For what purpose?
Because Lordship, there is a separate cause of action regarding Lordship, the screening committee's report. Separate cause of action. Lordship. That came to know in 2023, Lordship.
All right, we'll give you 1 week's time. You bring it by way of an additional affidavit, we'll consider. Bring it on record.
Screening committee's report.
Whatever you want to bring it. Position, your writ petition is for payment of area salary where you have been held to be irregular. There is an order by the department after screening that you are placed under list 1.
That is a report of 2023, Lordship.
Whatever it may be.
And this petition
In view of this report not being put to challenge, what orders do you want the court to pass in a matter like this? And this other writ petition that you have filed, you have made a statement there that there is a separate writ petition which is pending.
Regarding pension, Lordship.
No, pension you have filed here in this writ petition, 21.
21.
And in this you have made a mention reference to this writ, the 6435 writ petition.
Lordship.
That
it is regarding 2 writ petitions.
Certain service tenure with certain period, salaries, etc. have not been paid.
Lordship will list this matter after 2 weeks. We will challenge that also. In the meantime. Not by filing affidavit, we will challenge that.
Even this order is not under challenge.
Screening committee's report will challenge it.
No, page 182.
Cabinet gave approval on.
One 182, 184. Your claims for area salary has been rejected. Even this is not under challenge.
One 182, right?
Annexure B in the affidavit.
Oh. Order dated 21st March 2023. Order dated 21st March 2023.
Yes, it is also not under challenge.
We'll file a separate appearance challenging this. After 2 weeks, Lordship may release this matter. In the
No,
meantime,
no, what decision do you want us to, what orders do you want us to pass?
Lordship may adjourn this matter for 2 weeks. In the meantime, we'll challenge this.
Very well, you will challenge it, but what ultimate orders do you want in this writ petition? That is what we are asking you. Your prayers here have been, your prayer here has been already rejected by the department. Challenging that, you want to file a writ petition, which will give rise to another cause of action, which can be decided independently by the court.
Lordship, what they have stated, they have rejected our prayer for area salary.
Exactly.
But we have prayed that we should not be enlisted with the access teacher of Shivsagar district.
Which is the core issue why your prayer for area salary has been rejected.
But here, Lordship, the access teachers were not taken together, Lordship. Here, Lordship, they included us only. Our prayer has been rejected.
So I don't think it is anything will survive by keeping these writ petitions. We'll give
After
you
2 weeks,
liberty.
After 2 weeks, Lordship will release this.
At the request of learned counsel for the petitioner, matter stands deferred for 2 weeks. Mr. N.J. Khatonier appears for the writ petitioner.
Respondent.
For respondent.
For respondent.
Obligers.
Mr. Borpuzari for finance. Yes.
Extremely sorry, Your Lordship. I was stuck in another.
It's okay,
another
not a
Your
problem.
Lordship. In fact, my lord, my learned friend has shown one notification. I think my lord, repetitions are become infectious.
Okay.
Because
That is
has been withdrawn. Levy has been, my lord, withdrawn.
To condition number next.
Revised guidelines. That's good.
I am appearing in 5 to 9, Your Lordship. For
Right. Heard learned counsel for the parties. These writ petitions have been filed by
5 to 9, I am also representing. 4 is represented by my learned friend.
itu item given or present. 4 to 9. 4 to 9. Okay. Heard, who appears for item 4?
My lord, I am appeal.
Petitioner?
my lord,
Okay, in item 4, none appears for the petitioner, Mr. B.K. Das for railways. Railways.
Yes.
And item 5 to 9, Mr. Goel appears for the petitioners and Mr. Gogoi for, Dr. Gogoi
BN Gogoi.
For respondents, railways. These writ petitions have been filed, putting to challenge the notification / the rates circular number 32 of 2011 issued by the Government of India, whereby the respondents railways decided to levy penalty of rupees 5,000 on detention charges as per overloaded wagon in case of detention of a rake after weighment, warranting load adjustment at the originating station. Stop. The challenge is made to the circular on the ground that they are arbitrary and illegal, in view of the fact that the railways within bracket punitive charges overloading of wagons bracket close rules 2012, which is a set of rules framed under the Railways Act 1989, is already in place in respect of levy of any such charges in matters of overloading of wagons, and therefore the impugned rate circular number 32 of 2011 dated 16/9/2011 imposing further penalty for the same act amounts to double jeopardy or dual penalty for the same act or omission. It is on these grounds that the writ petitions have been filed, praying for setting aside and posting of the impugned circular number so and so, so and so, so and so. Para. Have you filed any affidavits?
Yes, Lord.
Railways have filed, responded by filing their counter affidavits. So, today when the matter is called up, learned standing counsel for the railways has placed before the court a circular dated 16/9/2020, whereby it is shown that under the revised guidelines, detention charge at the rate of 5,000 for overloaded wagon is not leviable, and this position has not been altered. Stop. It is submitted by the learned counsels for the railways that in view of this instructions received through the circular, these detention charges circular, rate circular has been withdrawn and is no longer in place. In that view of the matter, the challenge made in the writ petitions have become infructuous as on date. Stop. Para. Mr. Goel, learned counsel for the petitioner, does not dispute this position on facts. In view of such submissions made in the past, this writ petition stands closed as infructuous. Interim orders, if any, stand vacated. Copy of the circular dated so and so is extracted for is extracted in the order, and copy thereof is also kept in the case record. Writ petitions are accordingly dismissed as infructuous.
Deep.
Circular.
So for item number 4, my lord, there, my lord, I have not filed the affidavit, my lord. Lordship has
We have said
ordered-
some.
Yes, yes,
Yes.
some affidavit, some
some
file. I've adopted the affidavit, my lord. Obliged.
Yes.
In this case, the petitioner of lordship was appointed as Arabic teacher, my lord. And on 31/3/2001, he was appointed as Arabic teacher. He offered his joining, my lord, on 2nd of April 2001, but he could not join because against the same post, another person was appointed. Thereafter, my lord, he approached this honorable court, my lord. This honorable court directed the authority, my lord, to afford him joining. Thereafter, he was reappointed as assistant teacher. Initially, he was appointed as Arabic teacher. Subsequently, he was appointed as assistant teacher on 19/7/2001.
How many matters are listed here? Only one.
One, my lord. There was direction to my lord, tag with WPC 4787 of 2007 but perhaps my lord, that file could not be traced. That is the earlier of the litigation. My case is that my lord, as after appointment, I offered my joining. My seniority be counted from the date when I offered my joining, not from the date when I was allowed to join. Finally, after 9 years of my appointment.
Why were you not allowed to join?
My lord, initially, my lord, I was not allowed to join because another incumbent was appointed against the same post. Subsequently, my lord, I was not allowed to join by the public. It is their case. The respondent in their affidavit stated that I was not allowed to join because of public obstruction.
Hmm.
So I could not join. Finally, my lord, I was allowed to join in the year 2010, while I was appointed in 2001. And my service benefit has been given him since 2010 instead of 2001.
Yes.
I approached this honorable court earlier, my lord. This honorable court remanded back the matter, my lord. By the interim order, they have rejected my claim. And therefore, my lord,
What have you asked for?
I asked for the, my lord, benefit of the service from the date when I offered my joining.
What is your prayer?
Fine. At page 19, my lord. Page 18, my lord. The interim order, my lord, I have sent.
Yes.
For the secondary education department, Your Lordship.
Hmm.
Because this appointment order is by the inspector of schools, Your Lordship, BTC. Lordship.
You
And,
were not allowed to join, so you did not join.
I could not join.
What did you do in the meantime?
I was approaching the authority as well as this honorable court, my lord. This
Hmm.
honorable court, my lord, time and again directed the respondents, my lord, to afford him joining, but they could not.
Now, unless you join and work, how are you entitled to salary?
If I am restrained from joining,
Hmm.
I was I offered my joining, but I was restrained.
Have you filed any FIR or any application
Approach
to
this
that
honorable
effect?
court, my lord.
Hmm?
It's similarly situated, my lord, there is a direction of this honorable court in such a situation that service benefits should be given. I may not be paid the salary for the period, but my service should be counted from the date when I earned my
That can
job.
be done. There's no difficulty on that.
My
But
lord.
salary, area salary, unless you work,
My lord.
how it can be granted?
Seniority as well as the other service consequential service benefits, like increments. That if that is paid, I am happy, madam.
Huh? That can be done. Yes,
No. Also, we have filed a affidavit, Your Lordship.
your file.
Lordship is at page 70.
What is
Your
this
Lordship.
order at page 50? Is some judgment.
Yes, my
This-
similar order, my lord.
Huh?
Similar order, my lord.
And 57?
57 is the order passed in the case filed by the petitioner, my lord.
To what effect?
Remanding back the matter to the authority, my lord.
You decide.
My lord. And by the
What was the finding? What was to be decided?
Court of my lord, first services only, my lord.
Findings at page 61.
And
Your
what was decided?
directing the respondent to verify the claim of the petitioner as to whether he had actually submitted his joining report to the headmaster of so-and-so school on 2/4/2001. And if he, on such verification, finds the claim to be true, the interstate seniority of all the assistant teachers of Tangla High Secondary School shall be fixed by him.
What
Right?
was decided?
My lord,
Impugned order?
page 61, paragraph 4, my lord.
61. Yes.
Paragraph 4, my lord. The learned standing counsel appearing for the respondent does not oppose the submission of the learned counsel of the petitioner. Consequently, this petition is disposed of by directing the respondent, that is respondent number 4 and 5, to verify the claim of the petitioner as to whether he had actually submitted his joining report to the headmaster of Bornagar High School on 2/4/2001, and if he, on such verification, finds the claim to be true, the interstate seniority of all assistant teachers of Tangla High Secondary School shall be fixed by him by counting his seniority with effect from 2/4/2001. And in the affidavit, my lord, they says I offered my joining, but I could not join as another person was appointed against that post. So my findings is that he offered his joining.
Lordship, consequent to this order is the impugned order, your lordship, 63, page 63.
Sixty,
63,
Impugned order is page 63, my lord.
63, your lord.
On the basis that the petitioner could not produce the joining report, his claim was rejected.
where is the joining report?
Joining report, my lord, it is with the authority only, my lord. He submitted the joining report. And in their affidavit, they admitted that I offered my joining. I could not join because of another person joined against the same post. He could also peruse the affidavit filed by response number 3, 4, and 5. Paragraph 5.
1 minute. Come to page 63,
No.
second paragraph.
No.
Yes, my lord.
Kindly read.
From the report stated above and material available in record, it is found that Mohammad Rahul Amin Siddiqui was appointed temporarily as assistant Arabic teacher at Borgaon High School under Dorong district of Arsol BSc by this office order memo number so and so dated 31/3/2001. However, the headmaster of the Bornagar High School, the inspector of schools Odalguri and Dorong, respectively, has failed to produce the joining report in respect of the petitioner on 2/4/2001.
And what is stated in the affidavit?
Mine. In their affidavit, response number 3, 4, and 5, paragraph 5.
Hmm.
Where is my lord?
Yes.
Fifth line, my lord, but the petitioner could not join in his as the vacant post has already been filled up by Muhammad Samsud Tabriz, who was appointed as per order of government of Assam Education Department. I could not join because another person was appointed.
No, see, the position is like this. You could not join because somebody did not allow you to join.
Mine.
Then you joined,
Mine.
or at least you say you have joined.
My lord.
But the school did not have any record regarding your joining report. You do not have a record of joining report. How will the authority decide?
Then lordship may
The
kindly-
affidavit which has been filed, if you see carefully, para 6 is with regard to the statement that you could not join due to public obstruction.
Mine.
There is no dispute. You say, they say, even the order says.
Yes.
This is a statement stated to be true to the knowledge part and true to the records part.
My lord.
So we'll take it that it is a part of the record.
My lord.
But the statements at para 7 are stated to be true to the knowledge of the deponent that you could not join. You have joined on so and so date and has been rendering service. There has to be some record.
But they have not denied that I offered my joining. They have not denied that I offered my joining.
They have not. But now on the basis of mere statement, can we direct that his service benefits
In-
can be
in
something
that-
is has some record will have to be there, joining report.
My lord, in that case, lordship may kindly call for the record of the petition filed by the petitioner, first petition, my lord, in 2001.
which was disposed of.
Yes, my lord.
In this writ petition, this order passed by the court.
Yes, my lord. Interim order was passed by the Sonal Court, my lord. Page
This is
33.
WPC 3328.
Yes, my lord.
Is there a finding in the final order that record reveals that you are joined?
No, my lord. Here, my lord, this order was directed to, directed the authority to afford joining to the petitioner.
Where? Page
Page 33, my lord.
33.
My lord, 33, Annexure 4. My lord,
This is the interim order.
my lord. Well, I'm sorry, my lord, page 23 is the interim order.
Huh?
Page 23 is the interim order. I'm sorry, my lord. Page 23, my lord. Page 24, 11%, my lord. In the interim, the Director of Education, Borodan Autonomous Council, Kokrajhar, and the Director of Secondary Education, Assam, Sailipara, Guwahati. So herein are directed to give afford the place of posting of the petitioner, Mohammad Rahul Amin Siddiqui, in any school under them as Arabic teacher. Without disturbing that person, my lord, who was already appointed against the post.
So where were you allowed to join?
Finally, my lord, I was allowed to join at Tongla High Secondary School, my lord, in the year 2010. In Tongla, my lord, I was appointed in 2001. I was not allowed to join by the public. It is admitted case of the respondent that I was not allowed to join. And finally, my lord, I was allowed to join on 4/3/2010.
Your initial appointment was where?
Initial appointment was Bornagar, my lord.
Bornagar.
My lord.
Why you did not join there? Somebody else was there,
Against that post, my lord, one Samsud Tabriz was appointed.
appointed. So then the interim order was passed, permitting you to join
My,
in some school.
some other school, my lord. Then I was appointed in, my lord, Tongla High Secondary School.
Tongla.
Tongla High Secondary School. In Tongla High Secondary School, I offered my joining, but I was not allowed to join by the public. Finally, my lord, on various, after various orders passed by the Sonal Court, I was allowed to join on 4/3/2010.
Yes, PTC.
Lordship, in our affidavit,
Is there any dispute to the fact that he was not allowed to join? Number one. And subsequently he joined. On these facts, is there any dispute from the PTC?
Lordship, with regard to the earlier posting and joining, Lordship, there is no evidence or record that he was prevented from joining. But subsequent to the court's order, Lordship, after much persuasion, as reflected in the speaking order, Lordship, so from 2010, he was allowed to join and he is receiving regular salary.
So that earlier writ petition by which he was directed to join came to be disposed of.
Yes, ma'am.
By which order?
Well, uh, page 36, my lord.
All right. Heard learned counsel for the parties. This writ petition is filed by the petitioner who has approached this court for the following reliefs. Page number 18, 19. Stop. The facts necessary to adjudicate this matter are that the petitioner was initially appointed as an Arabic teacher and by the selection board and was posted at Bornagaon High Secondary School in the district of Dorong by an order dated 31/3/2001. Stop. It is the case of the petitioner that when he went to join in the said post, it was found that who joined? Person at number 2.
Samsud Tabriz, my lord.
He found that another person, namely Samsud
Tabriz.
Tabriz, had already joined in the said post and was working in the said school. Consequently, he could not join, end obligor was not allowed to join by the school authorities. Stop. Being thus situated, he has approached this court by filing WPC 3360 of 2001. This court on 14/5/2001, while issuing rule in the interim, directed the Director of Education, Directors of Education, Bodoland Autonomous Council, Kokrajhar, and or you say Director of Education, Bodoland Autonomous Council, Kokrajhar, and Director of Education, Director of Secondary Education, Assam, Kailipara, to give or afford the place of posting to the writ petitioner in any school under them as an Arabic teacher on the basis of the related appointment order dated 31/3/2001 without disturbing the place of posting of the said person, namely
Samsud Tabriz.
Samsud Tabriz, who was arrayed as respondent number 7 in the said writ petition. Stop. Pursuant to the order, interim order passed by this court, the petitioner was an order dated 19/7/2001 was passed, modifying the earlier appointment order, whereby the petitioner was appointed as assistant teacher within bracket Arabic in Tongla Higher Secondary School in a fixed pay of rupees 2,500 with effect from the date of joining. Stop. While the petitioner proceeded to join in his place of posting, he was not allowed to join by the people from the locality. Meanwhile, WPC 3360 filed by the petitioner came to be disposed of by order dated 30/11/2005, confirming the interim order earlier granted and making it absolute. Stop. It is submitted that Thereafter, since the petitioner was not permitted to join, he approached this court by way of another writ petition being WPC number 4787 of 2007. What was your prayer here? That in spite of the earlier orders stated, in spite of orders passed by the department, he was not allowed to join in Tongla Higher Secondary School. Stop. The submission of the counsel for the BTC before the court in the said matter was recorded to the effect that the Inspector of Schools, Dorong District, was already directed to allow the petitioner to join in Tongla Higher Secondary School as an Arabic teacher. Stop. Upon recording such findings, such submission by the Standing Council BTC, the said writ petition was closed, directing the Inspector of School to allow the petitioner to join in Tongla High Secondary School as Arabic teacher, and the petitioner was permitted to submit his joining report in the said school and to obtain necessary instructions to that effect, if required.
Was corrected because subsequently he was appointed as assistant teacher, not
Hmm?
Arabic teacher.
Hmm?
Initially, he was appointed as Arabic teacher. Subsequently, on 19/7/21, he was appointed as assistant teacher. So, my lord, this order has been corrected in the IA.
The petitioner was initially appointed as, the petitioner was thereafter permitted to join as what, assistant teacher?
Assistant teacher.
Assistant teacher Arabic. Stop. By an assistant teacher Arabic by the order passed by the BTC dated 28th of November 2008.
Assistant teacher Arabic, my lord.
What is this order at page 44? Okay, all right.
Presently, my lord, he is working as assistant teacher, not as assistant teacher Arabic. My lord.
At present, the petitioner is rendering his service. He's still working
Still working.
as assistant teacher in Tongla Higher Secondary School. Stop. The petitioner thereafter preferred a representation before the BTC dated 6/2/2012, praying for praying for release of area salary with effect from 31/3/2001. From the date of his first appointment order. This representation not having been disposed of, the petitioner approached this court again by filing. Was it disposed of? No.
No, my lord.
By filing WPC 3328 of 2012, which was disposed of by an order dated 27/3/2014, whereby the respondents, namely Director of Education and Inspector of Schools, were directed to verify the claim of the petitioner as to whether he had actually submitted his joining report to the headmaster of Bornagar High School on 2/4/2001, and on such verification finds the claim to be true. The inter se seniority should be fixed by counting his seniority with effect from 2/4/2001. The entire exercise was directed to be carried out within a period of 3 months. Stop. Pursuant to these orders passed, the Director of Education, BTC, had passed the impugned order dated, this is the impugned order,
Yes, ma'am.
15 December 2014, whereby the claim of the petitioner was rejected. Stop. In the impugned order, it was held that there is no record as to whether the petitioner had rendered his duty from 2/4/2001, and no such and record to that effect was not neither submitted by the headmaster Bornagar High School, nor was the joining report of the petitioner stated to have been submitted on 4/3/2010 was which was accepted by the Tongla High Secondary School, by the headmaster Tongla High Secondary School, was submitted before the authority. You are asking your seniority from which date?
From 2/4/2001, my lord.
But 2/4/2001 you could not join.
I could not.
Then how can you get your seniority?
I was prevented from joining.
No, because somebody else was already
Yes,
appointed. There was no question of prevention. There was no vacancy.
No fault on my part, my lord. It was the authority who had, my lord, appointed another person.
Maybe, but then that issue was never decided by the court.
Yes, that is.
Ultimately, the court directed you to be appointed any other school. So your claim for seniority will now be with effect from the subsequent order.
My lord, the order dated 19/7/2001, my lord.
I don't know what order is that.
19/7/2001, my lord. Page 30.
Huh?
Page 30, my lord.
30.
Page 30. Even from that day also, my lord, I'll accept, my lord. I was reappointed as assistant teacher on 97.
From that day.
My lord. Page 30.
Stop. Accordingly, the claim of the petitioner was rejected by the PTC. Learned counsels, the respondents have filed their affidavit, whereby the respondent, who is 345, BTC.
Yes, ma'am.
BTC had filed their affidavit, where in para 6 and 7 of the affidavit, there is an averment that the petitioner could not join in Tongla High Secondary School because of public obstruction. And Subsequently, he joined on 4/2/2010, and since then he has been rendering his services continuously. Any affidavit by school department? Okay. A similar stand has been reflected in the affidavit filed by the
That's number two.
respondent number 2, Director of Secondary Education. Vera. Having heard learned counsels for the parties and upon careful perusal of the pleadings on record as well as the orders passed by coordinated benches, it is seen that although the petitioner was initially appointed as Arabic teacher by order dated 31/3/2001 and posted in Bornagaon High Secondary School in the district of Dorong. From the order dated 14/5/2001 passed in WPC 3360 of 2001, it is evident that the petitioner could not join in the said school as some other person was already appointed. And therefore, a direction was issued to the respondents to provide alternative appointment to the petitioner. In pursuance to this order, the Inspector of Schools issued a fresh appointment order dated 19/7/2001, whereby the petitioner was appointed as assistant teacher in Tongla High Secondary School. Stop. The interim order passed by this court directing the respondents to furnish, to issue alternative orders came to be made absolute, was made absolute, and the writ petition was disposed of. Stop. These orders have attained finality as no review or appeal has been filed by the Department of School Education. Stop. Subsequently, the order dated what is the order at 44? Page 44.
Page 44 is the order, Malad, by which Malad the director of the Inspector of Schools Udalguri was directed to Malad take the necessary action, Malad, on joining of the petition.
কি লিখিলো আগৰটো?
Second paragraph.
Pursuant to the orders issued by the court, the uh, petitioner was permitted to join as assistant teacher, Tongla High Secondary School. Stop. However, because of public opposition, the petitioner could not join at Tongla Higher Secondary School. In this context, he had. Did you represent before the authority at that time?
Yes, I approached the authority, my lord.
Where is that? No representation.
Representation is not there, my lord.
It is the submission, it is the case projected by the petitioner that in spite of best efforts on his part, he was not allowed to join by the local people in Tongla Higher Secondary School pursuant to the orders passed by the Director of Secondary Education, BTC, the Director of Education, BTC. Stop. Under such circumstances, the writ petitioner filed another writ petition being WPC 3328 of 2012, whereby order dated 27/3/2014, the respondents were directed to verify the claim of the petitioner as to whether he had actually submitted a joining report to the headmaster of Bornagar High School on 2/4/2001, and if on verification they are found to be correct, inter se seniority of all assistant teachers of Tongla High Secondary School shall be fixed by counting the seniority of the petitioner with effect from 2/4/2001, and the said direction was required to be directed to be carried out within said action was directed to be carried out within a period of 3 months. Stop. By the in the impugned order dated so and so, it is seen that from the inquiry made, the joining report in respect of the petitioner in Bornagar High School was not made available to the Director of Education, BTC, either through the headmaster of the Bornagar High School or by the petitioner himself. Stop. However, the joining report of the petitioner dated 4/3/2010, which was accepted by the headmaster Tongla High Secondary School, is available. Stop. Pursuant to the said joining report, petitioner has been working in the said school in receiving regular scale of pay as well as his service benefits. Para. The issue which is raised in the present writ petition is the claim of service benefits and area salary of the petitioner with effect from the date of his with effect from 2/4/2001, which is claimed to be the date of joining of the writ petitioner in Bornagar High Secondary School. And it is the claim of the petitioner that his area salary and benefit of seniority has to be granted with effect from such date. Stop. However, from the pleadings available and the submissions made by the counsel for the petitioner, it is evident that pursuant to the initial order dated
31/3/2001.
31/3/2001,
my lord.
31/3/2001. Petitioner, although had approached the the Bornagar High Secondary School, he was not allowed to join as a person, namely so and so.
Tabriz something.
Huh?
Tabriz something.
Tabriz
Samsi.
Samsi.
No, I'm sorry, Samsud Tabriz.
Samsul Tabriz was already appointed as an Arabic teacher in the Said school. Stop. Therefore, there can be no question of the school authorities to accept his joining letter in respect of the Said post, which is already occupied by another teacher. Stop. No challenge was made to the appointment of the said teacher. And in the writ petition, which was preferred by the petitioner, being WPC 3360,
His appointment
sorry,
was put to challenge.
3360, although the same was put to challenge by interim order dated 14/5/2001, a direction was issued to the respondent to provide him alternative appointment, and which interim order came to be made absolute, and the writ petition was disposed of. Stop. The alternative order directed to be made available to the petitioner was issued by the department by order dated
19/7/2001.
Where is that page number?
Page 30, my lord.
19/7/2001, 2001, whereby he was appointed as an assistant teacher in Tongla Higher Secondary School. Stop. The claim of the petitioner that pursuant to the order dated 19/7/2001, when he had proceeded to join in his services in Tongla High Secondary School, he was prevented by local people and he was not permitted to join. And that subsequently, upon orders of this court, passed in WPC 4787,
My lord.
dated 13/6/2008, the inspector of school was directed to allow the petitioner to join in Tongla High Secondary School as Arabic as assistant teacher, the petitioner could join in the said service by submitting his joining report on 3/3/2010.
4/3, my lord.
4/3. It is written here 3/3, 4/3/2010. Stop. These facts are not disputed in the affidavits filed by the respective department. From a conjoined reading of the averments made in the affidavit as well as by the pleadings on, or as well as by the statements pleaded in the writ petition supported by the corresponding annexures, enclosures, it is evident that notwithstanding the order of alternative appointment being issued on 19/7/2001, the petitioner came to join in his place of posting only on 4/3/2010, that too pursuant to orders passed by this court dated 13/6/2008, passed in WPC 4787 of 2007. Stop. Whether the petitioner deliberately avoided from joining in the said post or he was prevented to join in the said post by the local public or other reason is not inquired into by the respondents. The affidavits make it very clear that they accept the contention of the writ petitioner that he was prevented from joining in Tongla High Secondary School by the respondent, by local people. Stop. If that be so, then it cannot be said that the petitioner deliberately avoided or failed to join in his place of posting as assistant teacher in Tongla High Secondary School. Deliberately. Stop. it will have to be held that he was prevented from joining by reasons beyond his control. Stop. If that view as discussed above, that position as discussed above is reflected in the affidavits filed by the respective departments. Stop. Under such circumstances, this court is of the considered view that the petitioner cannot be deprived of his service benefits for no fault for no fault which can be attributed to the petitioner. Stop. Accordingly, it is the view of the court that the petitioner ought to be entitled to his service benefits from the date he has joined in his substantive post pursuant to his alternative appointment made alternative appointment issued by the department by order dated 19/7/2001. Stop. It is held that the petitioner will be entitled for his service benefit with effect from 19/7/2001 till he was permitted to join on 4/3/2010 as assistant teacher in Tongla High Secondary School. Stop. However, considering the fact that there is also no dispute that the petitioner did not render any service with effect from 19/7/2001 till 4/3/2010, he will not be entitled to any salary or arrear salary in that for that period of time. Stop. The service benefits as directed be conferred on the petitioner, and seniority, if any, as may be granted to the petitioner, as may be available to the petitioner in terms of the service route, be ordered accordingly by the appropriate authority within as expeditiously as possible. So the department will now proceed to pass necessary orders conferring the service benefits to the petitioner with effect from the date of his subsequent appointment, alternative appointment, which is 19/7/2001, till his date of joining in the substantive post of assistant teacher in Tongla High Secondary School on 4/3/2010. So this exercise be completed within a period of 60 days from the date of receipt of a certified copy of this order. Writ petition allowed to the extent indicated above and disposed of. Yes.
My lord, one aspect, he may be entitled to the increments, my lord, not the area salary. The increments may be counted, my lord, with effect from 19/7/2001, my lord. He'll be getting lesser salary, my lord. That can be given.
The benefits of financial benefits bearing his area salary as payable under the provisions of law may also be released to the petition.
Deeply obliged.